draft Windsor Framework Constitutional Status of Northern Ireland Regulations. Minister or Secretary of State to move.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the Committee of the whole House has considered the draft Windsor Framework Constitutional Status of Northern Ireland Regulations 2024. Getting devolution back up and running has been the principal focus of government policy in Northern Ireland since February 2022, when the then First Minister resigned. The agreement that the Secretary of State set out before the House yesterday, or me, sorry, I'm reading someone else's speech now. The agreement that I set out before the House yesterday is designed to secure the widest possible support amongst the community in Northern Ireland for participating in the political process. These regulations should be seen and considered in the context of forming part of a package. This package will safeguard and durably strengthen Northern Ireland's integral place in the Union and the UK's internal market, and do so by placing commitments in that package into law. Mr. Speaker, the Windsor Framework Constitutional Status of Northern Ireland Regulations 2024 affirm, strengthen and future-proof Northern Ireland's place within the Union, underpinned by the Acts of Union and also the terms of the Northern Ireland Act 1998.
Will you give way?
I'll happily give way to my
Very grateful to Secretary of State. If the Chancellor of the Exchequer wishes to lower the VAT rate or wishes to take something out of VAT altogether, will that be a good law for Northern Ireland as well as the rest of the United Kingdom? And can we now settle taxes for the whole country?
The example he's just given on VAT, yes, and it's just been done on a number of different things. I believe the latest was possibly solar panels, but I'll check in the box, and certainly various other products, which I'll get for the honourable gentleman. But yes, is the answer for VAT, certainly. And also tax. They address these concerns, the concerns that have been expressed amongst parts of the unionist community in Northern Ireland that has had its status diminished. Let me say here, and from the outset of our discussions, what the government wanted and the DUP wanted was and what we had was our shared determination to strengthen our union. I'll happily give way.
Can I sincerely recognise the efforts of the right honourable gentleman, his team and his colleagues in achieving what they have achieved over the last week. One of the most encouraging things, I think, in the last week is that leaders within nationalism and unionism have all emphatically said they want to make Northern Ireland work. We all have different views on the constitutional future, and that is a discussion and debate that is ongoing. But if unionists want to make Northern Ireland work and nationalists want to make Northern Ireland work, regardless of that, everyone benefits.
Can I completely agree with the honourable gentleman? It's been a pleasure to work with all the party leaders over the course of the time I've been Secretary of State, and I'm absolutely convinced. Indeed, I've seen them work together behind the scenes on a number of different occasions, and it was striking actually last February when a DCI, a police officer was shot John Corbell was shot by dissident Republicans, how all the political leaders of Northern Ireland came together in such a strong repudiation of that attack. And I've seen them work behind the scenes together on a whole host of things. And I know that when Stormont is up and running, they will be able to deliver strong government, make the right decisions for Northern Ireland, and make Northern Ireland a much more prosperous place. So I thank him for his intervention. He's absolutely right. Yeah, I'll start just that paragraph again, if I may. Let me say from the outset of our discussions, what united the government and the DUP was our shared determination to strengthen our union. And I just got to that bit. Yeah, go on.
There was a memorial service on Tuesday for somebody who I think never gets enough credit for their role in the peace process. Peter Brook once said that Britain had no selfish or strategic interest in Northern Ireland. That was later repeated in the Downing Street Declaration. Reading the command paper, it would seem to me that this government has moved from that position, and I think undermines the Good Friday Agreement. It seems like they've moved away from the principle of rigorous impartiality. Does the Secretary of State agree with Peter Brook's assertion and the Downing Street Declaration, or is he moving to a different place?
Peter Brook was wrong.
I disagree with what you said, what the Honourable Gentleman said at the very end of his intervention, and I completely agree with what Sir Peter Brook said at the time, and our commitment to the Belfast Good Friday Agreement in all of its different ways, all its assets. And I wanted to say that our determination to strengthen the Union, and the Right Honourable Member for Lagan Valley has powerfully argued that strong and effective devolution, delivering a thriving Northern Ireland within our United Kingdom, is the surest way to ensure this United Kingdom remains united in the time ahead. So in taking the steps that he has taken, let me say he is delivering far more for the future of Northern Ireland in the Union than any of his detractors. Happily give way to my right honourable friend.
For giving way, could he outline a list or a summary of what those who are against the Right Honourable Member for Lagan Valley's deal have actually achieved in their months of campaigning?
Yes, in round figures.
I would love to be able to outline anything. I've got a piece of paper with it. Oh, it's blank. Nothing. Absolutely zero. I'm afraid the postage stamp is too big to write on the back of for what they've achieved. So I can absolutely say, I mean, there is so much that the Right Honourable Gentleman has achieved in this deal in safeguarding the Union, and his detractors have not come up with anything. And the changes he has secured in these regulations, and the other instrument that is before this House and we will consider shortly, will further enhance those protections. The regulations end any presumption that there is any form of automatic and unchecked dynamic alignment with European goods rules. Section 7A, the so-called pipeline of EU law, is now expressly, of the Withdrawal Agreement, is expressly subject to the operation of vital democratic safeguards that the Northern Ireland Assembly, when sitting, will be able to exercise, including the Stormont break. And indeed, when, and I use the word when, Stormont begins to sit, when it first assembles, I will be able to sign that Stormont break legislation into law, and the availability of it to be used will be available to will be there for the Assembly as we move forward. When Parliament passed the EU Withdrawal Act 2018, it was exercising its sovereignty so that the UK-EU Withdrawal Agreement could be implemented in domestic law. I'll happily give way to the Honourable Gentleman.
Sammy Wills.
He indicates that there are now, and he said it in plural, vital democratic safeguards to guard against EU law, including the Stormont break. Could you tell us what the other safeguards are?
Yeah, I mean, we've got the Withdrawal Act itself, and indeed he's sitting in a place that safeguards our laws themselves. And it is right that we are updating our domestic law to reflect that democratically elected representatives in Northern Ireland will now be able to reject new and amending EU law, and that the withdrawal agreement's implementation is subject to robust scrutiny.
What will my right honourable friend allow?
I'll happily allow from Gainsborough first.
Already the ability of ministers to govern is severely constrained by things like the Human Rights Act. What worries me about all this is not the deal as such, but I'm a Brexiteer and I want us to have a dynamic and deregulated economy. What happens when we try and diverge from EU laws? Will some civil servant have to sign this off? And it will be a question of no minister before we even get to the House of Commons. Can he assure me, therefore, that we will be able to enjoy our Brexit freedoms under this deal?
I thank the Honourable Gentleman, for his question, because it has been put before yesterday, and it's a genuinely fair question. And I can honestly say to him that this package of measures will not change the freedoms and powers we have secured through leaving the European Union or through the Windsor Framework. I've just finished answering. I will just finish answering my honourable friend's point first. It will not reduce our ability to diverge, nor our commitment to do so, should it be in the interests of the United Kingdom. And if the legislation does carry significant adverse effects, of course the House would expect the Minister to set out any steps to be taken in response to this assessment. And I'll happily give way to my right honourable friend.
As my right honourable friend may expect, I shall now refer to section 38 and ask him a question about it, because under the amendments that are made under the statutory instrument, which is not by Act of Parliament, of course, I just mentioned this point, which is that the arrangements under the section 38 state that the Parliament of the United Kingdom is sovereign, that its sovereignty subsists, notwithstanding section 7A of that Act, including the Windsor Framework. My right honourable friend will know what I'm saying. So in practice and in law, constitutionally, there is the capacity for the override not only of the withdrawal agreement and the protocol, but also the Windsor Framework as a result of what is contained in those words.
Well, I note the honourable right honourable gentleman's point, and you know, as I said yesterday, I mean, I hope he recognises actually what we are doing in this statutory instrument is the addition of Northern Ireland, making the addition of Northern Ireland's place in the United Kingdom, and a very strong, one second if I may, addition to this clause. And as I said to him yesterday, his original clause has been a big part of the solution to this conundrum. I'm really grateful to him for it, and I completely understand the point he's just made, and thank him for it. And I give way to the honourable gentleman.
Listening to the Secretary of State and reading the command paper, you would maybe think that there's only the DUP in Northern Ireland. There are no other people with any other constitutional preferences. Of course, there are many people in the north of Ireland who want to see a new Ireland as soon as possible. So despite what might be in the command paper and what he has said and others have said, does he agree that the Good Friday Agreement is sacrosanct, and it's absolutely clear that if people vote for a constitutional change, then that's what happens? It's not up to the British government or anybody else, it's up to the people of Ireland, north and south.
Yes, nothing that we're doing here changes that fundamental principle, so he's absolutely right to make that point, and I hope I've clarified it for him properly. I'll happily give way to my right honourable friend.
Thank you, Mr. Speaker, and to the Secretary of State. Further to the point made by the Honourable Member for Foyle, the difficulty was that the Northern Ireland Protocol, in the eyes of Unionists, undermined the principle of consent, which is at the heart of the Good Friday Agreement. Does he agree with me that these new measures and the legislation resets the balance so that it is the principle of consent and the will of the people of Northern Ireland alone that will determine the future of our country as part of the United Kingdom?
Yes, and I actually think that both the right honourable gentleman and the honourable gentleman are making exactly the same point, and rightly so. They represent two communities that have governed by consent in the past, and the whole point of what we're doing here today is to try and get government by consent back up and running in Stormont in the future. Of course.
As one in living memory who served as Minister for the Environment and for Agriculture in Northern Ireland, because the Northern Ireland political process wasn't working, can I say that as well as the exercise in syntax and the like in the writing of these instruments, the key point is that the Assembly should be effective and ministers should come from Northern Ireland doing the jobs that we don't want to have to do from Westminster.
Anyone who ever becomes Father of the House is obviously wise and well experienced, and that was a particularly wise comment from a particularly well experienced right honourable gentleman, and he is completely right in everything that he said. Crucially, this legislation will also change the law so that new regulatory borders between Great Britain and Northern Ireland cannot emerge from future agreements with the European Union. This is an important new safeguard to future-proof Northern Ireland's constitutional status. No government in the future can agree to another protocol, nor can the UK internal market be salami-sliced by any future agreement with the European Union. This legislation will also introduce safeguards so that government bills that affect trade between Northern Ireland and other parts of the United Kingdom are properly assessed. Ministers in charge of such bills will need to provide, as the Right Honourable for Gainsborough just raised the point, will provide a written ministerial statement to Parliament as to whether a bill would have significant adverse effect on trade between Northern Ireland and another part of the United Kingdom. And if the legislation does carry that significant adverse effect, of course, the House would expect the Minister to set out any steps to be taken in response to this assessment. And indeed, we have Select Committee chairmen present who would expect to do high levels of scrutiny in that space. But this is a very good transparency measure that I think we should all welcome. And I have to give way to my right honourable friend.
I'm very grateful to the Secretary of State for giving way, and he's repeatedly said that the deal we're looking at today will not prevent Britain from diverging from EU laws, which is obviously welcome. But on page 17 of the command paper, it says, we will also set out plans to introduce legislation in the spring that would avoid new regulatory divergence between GB and NI on veterinary medicines. So is the command paper saying that in that area there will be no future divergence?
What we're saying in the command paper is that we, in fact, if you go through paragraphs, if the Honourable Lady, sorry, Right Honourable Lady, goes through paragraphs 136 to 141 in the command paper, you'll see that we state the current situation we know is not right. We've got a grace period at this point in time that's going to run out quite very soon. We want to find a solution similar to the way we found a solution, and the solution we would like to see is the one that we found for human medicines. We want to set up, it's been suggested we set up, we want to set up a working group of experts and people who really truly know and care about this subject to look at this very, very quickly, come to ministers and Parliament with a solution to that, which we will take to our European partners and negotiate hard to get. So it's not, as she quite states, it's actually a process to get to a point where we have a settled view from this House and indeed experts from Northern Ireland in this space where we can really move forward on this matter. And I know that that's a very important matter to all members from Northern Ireland. This transparency, what I've just stated before the intervention, will increase transparency by ensuring Parliament is presented with evidence of GB-NI trade impacts of relevant legislation before proceeding with it. These concrete steps that we are taking and enshrining in law will deliver clarity to business in that Northern Ireland's unfettered access to the UK internal market will not be threatened by a new regulatory border. And finally, with this legislation, the government will provide for additional duties and further requirements in statute regarding the operation of an independent review of the Windsor Framework, reflecting our steadfast commitment to ensuring that the framework operates on the basis of the broadest cross-community support. I, as Secretary of State, will be put under a duty to commission a review within 1 month of the Assembly having passed a consent vote, but one without cross-community consent, and will be obliged to respond to the report from that review within 6 months. This constitutes a new and important commitment by this government. These are all steps we are taking, and they're all designed to ensure that tangible action is taken off the back of a review and solutions that are found, with government ministers being placed under a legal duty to raise the contents of the review at the UK-EU Withdrawal Agreement Joint Committee. Yes, to the Honourable Member.
To the Secretary giving way. Could I just ask him to clarify a little further in terms of this independent review into the Windsor Framework? As a Secretary, I would appreciate there's a spectrum of views on the Windsor Framework. It is worth restating that most people in Northern Ireland, most elected representatives, most businesses are pragmatic around it. There are those, of course, who are opposed to it. Can he assure us that this will be a genuinely independent review that will take on board the full spectrum of opinion, not least in the context where the Assembly would at that stage have actually confirmed ongoing support for the Windsor Framework?
I can give him that confirmation, and it will be for ministers to make sure that the panel is completely independent. And there was the honourable gentleman.
Thank the Secretary of State for giving way. Just on the point of regulatory issues which are currently Northern Ireland, several laws have been passed in Europe. We hear that there have been up to 300 that have went through from we agreed to leave. On the basis of that, some of those are already in place in Northern Ireland. Is there a possibility of looking at those which are currently implemented and seeing will they be part of the review and ensuring that those that we can get rid of, we can, and that mechanism should be in place?
Review is essentially, well, it will be based on the entirety of law, but essentially it has to look forward. And the point I'd make to the honourable gentleman is that he's right. There is always a pipeline of European Union law. I was a member of the European Parliament for 10 years. I saw firsthand the quantity of law that came from the European Union. And I'd just make the point that had we been able to get to this place earlier, we would have had, hopefully would have had the Stormont break in operation earlier, and actually we might well have been able, representatives of Northern Ireland communities, assembly members, might well have been able to trigger the Stormont break and seen that in action. But I very much hope that we'll see it in action in the future to demonstrate its worth in that space. Of course, Honourable.
It's worth making the point that whilst he's right in the response that he has given in terms of the review that was the subject of the question from my honourable friend, and he raises the right concern, but of course he is also right to focus not only on the democratic scrutiny and accountability mechanism, which isn't before us today, has been legislated for, was a change to the Northern Ireland Protocol. He will know that, of course, within the series of SIs, there's also a proper amendment here in this UK Parliament to Section 7A of the Withdrawal Agreement, which turns particularly to that pipeline. And thirdly, and again, a sense of how regulations have been changed through this process. On Tuesday evening, whenever the European Union and the UK government reached agreement around what was contained within the red lane on rest of the world products, and 60 pages or more of legislative text and change were published and show the benefit not only of regulatory barriers that could be created in the future that are being dealt with in this legislation, but that as part of this overall package, some of those barriers have already been removed.
I could not have put it better myself, Mr. Speaker, and the honourable member is very knowledgeable about these subjects, and indeed has been well involved in the negotiations behind what we've the document we are talking about and the statutory instruments we are talking about, and so he's absolutely 100% right. Absolutely.
If I may, and ask a question. Does my right honourable friend, who himself was on the European Scrutiny Committee, recognise that we too are constantly monitoring it, and the honourable member who's just spoken is on that committee?
I had the pleasure of serving for 5 years on the European Scrutiny Committee under the wise chairmanship of the honourable right honourable member for Stone, and he's absolutely right. And I think, I mean, this is what this House does best. This is what the Select Committee system is for, to scrutinise all different aspects of both legislation and what government does, and indeed what comes our way. And I know his expertise, but having experienced it. But when we were members of the European Union, wading through the hundreds of different explanatory memoranda that came the committee's way was quite a job and a responsibility. And so actually one of the commitments we have made is how we will make sure information is freely available to Assembly members in Northern Ireland when they take their seats, to ensure that they can do democratic scrutiny of proposals that might well affect Northern Ireland themselves, so they have the information, should they choose to use it, to use this Stormont break. Scrutiny is a vital part of all of this, and he's absolutely right. Happily give way to the honourable member.
Thank the Secretary of State for giving way. Over the last 2 years, Secretary of State, you'll know it, and probably everybody in this side of the House knows it as well, I've done lots of consultation, lots of discussions with party groups, with the Orange Order, with those in the NHS and many other people as well, seeking the opinions of community groups. From all that comes where we are today. I suspect, and I would probably like to say that this is not the fulfilment of the whole wishes of what we wish to see. And with that in mind, I want to ask one question if I can. The constitutional legislation is here, the legislation to secure a place within the internal market, but I still retain, and my constituents retain, some level of concern and press the government for more assurance. It was highlighted yesterday that the European laws may be overruled by government, but the wording of that suggests they may also be accepted, allowing Northern Ireland to diverge. So I want to ask the Secretary of State, does the last word lie in this place, or does it lie with the EU whenever it comes to making those decisions? Thank you.
Well, actually, so, I mean, should it be an element of law that would be triggered by the Stormont break? I think the biggest say would be with Assembly members. This place, though, Parliament is sovereign, and he will know that this place has already chosen to for GB to Great Britain to diverge from Northern Ireland. There's the matter of animal welfare livestock exports, where this has happened, and for good reason, because Northern Ireland has a land border and a vociferous and lively trade in live animal exports with the Republic of Ireland. And were you to stop that from happening, were the ban in Great Britain to be extended to Northern Ireland, it would affect the export of around 3,500 cattle, 1,700 pigs, 337,000 sheep, etc., which were moved to that were the figures of livestock moved to Ireland from Northern Ireland in 2022. So this place does make those sorts of decisions already, and will continue to do so. Absolutely give around that point.
He's at odds, actually, in making that argument. That was one of the arguments made by the Minister when saying why Northern Ireland should be excluded. But the reason that was given was that because Northern Ireland is part of the EU single market, there could not be discrimination between goods or cattle being transferred to the Republic of Ireland and cattle being transferred thousands of miles away to the south of Italy. That's the real reason that this House once again found itself subservient to EU rules in Northern Ireland.
I'm afraid the honourable gentleman is wrong. Completely wrong. And I know he's written to my right honourable friend, the Minister of State for Food, Farming and Fisheries. I have the reply, which has been copied into here, almost expounding that some sort of carve-out should be made in some way. But this is on the basis of a range of international agreements and their core principles, including the World Trade Organization. As much as a good Eurosceptic as I am, I'm very careful not to blame the wrong organisation for the wrong things. We have signed up to the World Trade Organization rules. We benefit from those rules. This is one of the elements of this is because of World Trade Organization rules, and he's picking the wrong thing to point his finger at this point, because it prevents discrimination against different countries in all sorts of different ways, and they're very important and vital rules too. So I'm afraid, on this particular point, he is completely wrong. Mr. Speaker, I have long been clear to honourable and right honourable members that I serve in this government proudly as a unionist. I'm pleased that the regulations I commend to this House today will address the concerns expressed by part of the community in Northern Ireland over the past years that our Union of Nations has been somehow diminished as a whole. The regulations demonstrate that the government has listened so that trust can be rebuilt, so that people and businesses can be reassured of the UK's long-term future, of being in the UK's long-term future, and so that we can see Northern Ireland political institutions restored. Happily give away to my right honourable friend.
Obviously, we're debating the SIs, but can I just point honourable and right honourable members to Annex A of the Government Safeguarding the Union document? It's an excellent summary of the actual historical context of the Acts of the Union, including Article 6. There's been many keyboard warriors across Northern Ireland who I'm not sure actually what they've achieved over the last 8 months other than to create a whole kerfuffle. They would be well advised to read this, and they can then see that actually none of the Acts of the Union are under threat in any way.
And I thank my right honourable friend for making that point. He's absolutely right. There has been a lot of noise, a lot of heat generated in many ways, but Again, by people who've absolutely done nothing in this space and are clouding, are trying to cloud the reality that he absolutely expresses, and we have set out in the annex for everybody to see. So I very much hope that honourable and right honourable members will welcome the progress we have made in delivering this agreement through supporting the passage of these regulations, and that in coming days they will join me in welcoming the return of Stormont so that the Assembly and the Executive may serve the people of Northern Ireland once more. Of course, I'll give way to the honourable gentleman.
Very generous, and I thank him for doing that, and I always try to be constructive, and he knows that. And it is for all those people out there, my constituents, who have concerns and probably don't have the trust in government for the very genuine reasons that we've been, forgive me, been let down on a number of occasions. So again, I'd ask the Secretary of State to reiterate once again, and in my apologies for doing so, with his hand on the dispatch box. We all know what that means. And aware of the duty of possession places us to answer in simple terms for my constituents. Does this deal constitute the renewal of our place within the constitutional and economic United Kingdom of Great Britain and Northern Ireland as fully and as completely as any other area within this great UK?
I believe it does, 100%. Mr. Speaker,
Will you give way?
I'll happally give way to the Vice.
Very much. Someone wanting to send goods from GB to NI would naturally expect to use the new internal market lane, the green lane. Who decides whether they're not allowed to? Is it the EU, the UK government, or the Stormont government?
It's the UK government in that area. Let me go to the right, the honourable gentleman there first.
Thank the Secretary of State very much. Further to that point, in paragraph 96 of the command paper, could he outline to us, is he expecting in the pipeline more SIs to come to give full effect and impact and clarity to the issues that have been raised in this wide-ranging command paper?
So we would give legal direction to DERA on those matters. So, and there are actually other legal instruments that we're going to use for this deal, but that would be for us to give legal direction to DERA on that point. I'll give it right to the honourable gentleman.
Grateful to Secretary of State for giving way. We all accept that the DUP had a particular issue around all of this, but does he accept that it's not good practice in Northern Ireland to have a one government, one party process? And will he commit in the future to have a much more inclusive process for dealing with all of these types of issues?
I thank the honourable gentleman for his point, and he makes it fairly. But to be honest with him, there was one party that was staying out of government that represents a community, and so as much, and I did try to keep him as updated as I possibly could throughout this whole process, as we have done with the other political parties. But the party we needed to persuade to go back into government, I needed to talk to more. And I hope he'll, I mean, on a future basis, I will always try and treat everybody equitably. But I hope he understands that I had to make sure that there was an agreement that the Democratic Unionist Party could stand behind, and I could rebuild trust. The Honourable Gentleman for Strangford used the word trust. I could try to start to rebuild the trust that had been lost between the Democratic Unionist Party and the United Kingdom government, and that's something we had to do between the two. But I'll happily give way again.
I'm grateful to the Secretary of State for giving way again. I just think it has to be understood that there are more people in Northern Ireland than just the DUP and just unionism. And nationalism feels, I think, that North-South has been undermined with a massive emphasis being put on East-West. And I would just ask him to think carefully about that. The command paper, for me, undermines the Good Friday Agreement, undermines North-South, and is far too far in the direction of where the DUP's thinking is.
So forgive me, the honourable gentleman is a friend of mine, so I hope he doesn't mind me disagreeing with him in this way. But the command paper, I hope, will deliver the restoration of Stormont, a very important, the most important institution, strand one of the Belfast Good Friday Agreement. It also would allow for ministers to be appointed to the North-South Council, a very important institution of a different strand of the Belfast Good Friday Agreement, which would then be allowed to function properly. What this command paper does is allow for all strands of the Belfast Good Friday Agreement to start humming again as they should. And so forgive me, So forgive me, I have to disagree with him on that point. I'll give way to the Honourable...
I'm very grateful to my right honourable friend for being so generous. Doesn't it all boil down to this, Madam Deputy Speaker, as outlined in Annex A, that it's important to make a difference between Northern Ireland's integral place constitutionally within the United Kingdom and its internal market, and the access that it has to the single market as a result of its unique position. And those two words, the difference between access and its constitutional place, are the things we really need to focus upon when trying to square this circle.
I thank my right honourable friend, the Select Committee chairman, on this. And yes, I do agree with him. And it's a very important point that he makes, and he makes it eloquently as ever. Mr. Speaker, Madam Deputy Speaker, very nice to see you in your place, and I'm sorry I didn't see you come in. Madam Deputy Speaker, these regulations undoubtedly will strengthen the Union. It's for those reasons, and more, that I wholeheartedly and unequivocally commend these regulations to the House.
The question is the motion on the draft Windsor Framework constitutional status of Northern Ireland regulations as on the order paper. Shadow Secretary of State Hilary Benn.
Thank you very much indeed, Madam Deputy Speaker. I am grateful to the Secretary of State for his explanation of the first set of regulations we're considering, and I join him in wanting to see the institutions up and running again as soon as possible. I welcome these measures and we will support them from this side of the House. Ever since leaving the EU created the problems which have caused Northern Ireland to be without a government for 2 years, we have been trying as a nation to find a common sense way through. And these SIs are a continuation of that process to balance two objectives. One, to enable the free flow of trade between Northern Ireland and Great Britain, and the second objective, to make sure that goods that enter the Republic across the open border meet the rules of the single market. Now, we should also note in this debate the further commitments, reference has been made, that are contained in the command paper that was published yesterday, and we look forward to regulations and guidance to implement these where they are required being brought forward, perhaps in the future with a little bit more time to read them, although I understand completely and support the timetable we're dealing with today. Can I commend the Right Honourable Member for Skipton and Ripon for drawing the House's attention to the annex of the command paper to do with the history, because I certainly learnt some things reading that I was not aware of. And when I hear the argument put, well, there was always free and unfettered trade and now it has changed, to discover that the Government of Ireland Act 1920 required that the movement of goods between Great Britain and Northern Ireland should be treated as exports and imports, and that customs officers were instructed to conduct physical inspections of ships and daily sailings twice weekly at a check rate of 28%. It's a jolly good idea to understand your history, and as one is trying to deal with the problems of the future. Of course I'll give way.
I thank the Shadow Secretary of State for giving way. Indeed, when some suggest that the Acts of Union should be as they were in 1801, does he agree with me that the Honourable Member for North Antrim would be very perplexed to discover that a bottle of Bushmills whisky distilled in his constituency would have a £3 tariff added to it to be sold in Great Britain, the rest of the United Kingdom? Does he agree with me that we certainly don't want to go back to that?
Well, I say to the right, I am a teetotaler, so perhaps I don't feel the suffering of the example that he's just put before the House in the same way that other members do, but he is a very observant student of the history of Northern Ireland, and he makes his point extremely forcefully. Of course I'll give way.
Does the Honourable Member, however, recognise the difference between a tariff being put on either by this Parliament or by the Assembly or a Parliament in Northern Ireland, where the people in the country electing representatives take a decision, and tariffs which act as an impediment to trade being imposed by an outside body such as the EU, which is the case in Northern Ireland. And that's how the Act of Union is being disrupted, because an outside body can interfere with it.
Well, I would say to the honourable gentleman, Madam Deputy Speaker, you know, we've seen quite a lot of disruption to arrangements in recent years, have we not? And the point I tried to make a moment ago is that, given the fact of our departure from the European Union, there was a problem. Everybody knew there was going to be a problem between Northern Ireland and the Republic because of the open border that everyone continued to support. That was, I think I said last week, about the only thing in Brexit where there was agreement. And therefore, if there's a problem, you have to find a way through it. And what we're grappling with here, have done previously, and may do in the future, is how you solve that problem, which is the result of a democratic decision taken by the British people. Now, turning to these particular regulations, part of what is before us updates previous legislation to include references to the Windsor Framework, because it came after the pieces of legislation, or reaffirms for clarity the existing legal position. I welcome the prohibition made by Regulation 2, subsection 3, of any agreement with the EU that would create a regulatory border between Great Britain and Northern Ireland. I would note, however, that if we were to form the next government, Labour would seek to negotiate an SPS agreement with the EU with the intention of removing checks on animals, food and plants, not only between GB and NI, but between the whole of the UK and the EU, which would, of course, benefit farmers, food businesses, the horticultural industry in Northern Ireland and the rest of the United Kingdom. With regard to Regulation 3, this amends Section 7A of the EU Withdrawal Agreement Act to include a reference to the Stormont break procedure and the democratic consent vote. And I note that the Secretary of State said that the Windsor Framework democratic scrutiny regulations that were passed by Parliament back in March will take effect. I think he said he'd sign them once the Assembly is back up and running, and he nods in assent of that understanding. It's also important to remind ourselves of the significance of those regulations and the democratic checks they will create. The Stormont break will be available to the Assembly, where the EU is seeking to amend or replace existing EU goods legislation in Annex 2 of the framework. And of course, the Windsor Framework gives a new role for the Assembly in approving or indeed rejecting any proposed new EU legislation from being added to the framework. I note that on page 47 of the command paper, it says that the full operational details for the Stormont break will be set out in writing for the Assembly. Can he confirm when this will happen and what form will this take so that we in the House can see it? I will give way, of course, to the right honourable gentleman and then my honourable friend. Yes.
Right honourable gentleman, if he accepts that there is a distinction between new and amended legislation in this context, and it's not by any means the same thing, particularly as amended legislation can be very extensive.
I do take that point, but there are two separate categories we are talking about here. One relates to the legislation that formed part of the original protocol in the annex, and it's a long list. Another relates to new stuff that is coming along from the European Union. I give way to the honourable.
I'm very grateful to the Shadow Secretary of State for giving way. Would you recognise that there is a different school of thought within Northern Ireland by some people and businesses around the Stormont break, in that if there is a degree of delay or uncertainty as to the application of an updated EU regulation, that could actually inadvertently undermine Northern Ireland's particular advantage in terms of dual market access by creating that uncertainty for businesses seeking to invest or remain in Northern Ireland. By far the better way is for Northern Ireland institutions to begin at the start and talk to the European Union to make sure our concerns are reflected as fresh EU law is developed or updated EU law is undertaken.
Well, the honourable member makes an extremely powerful and useful point, because the businesses I've spoken to in Northern Ireland, they are very supportive of the access that Northern Ireland has to the EU market, and in choosing to pull or not pull the Stormont break, There are many considerations that I'm sure elected politicians in Northern Ireland will take into consideration. And let's be honest, it depends, what are we talking about here? What impact will it have? Does it have a really bad effect, in which case people might reach for the brake? In other respects, it may be a perfectly sensible change and nobody needs to worry about it. But there is a mechanism now that gives Northern Ireland politicians and the Assembly the chance to decide between the two, of course.
I'm very grateful to the right honourable gentleman giving way, but further to that point, which is a very good one, wouldn't the EU decide to use its powers if Stormont tried to use the brake too often and change the amount of EU law that applied?
Well, the Stormont brake was the result of a negotiation between the government and the European Union. It was a really big step forward. That's why we're having this discussion now, and I support it. Anything is possible in the future as to what one or other party that are engaged in continuing discussions and negotiations may seek to do, but we have a deal with the European Union, and they expect us to honour the Windsor Framework, a point I've made in the House many, many times before, and we would expect them to do entirely the same. But nobody can guard with absolute certainty about what may happen in the future. We have to deal with the world as it is today. I give way to the right honourable gentleman.
I thank my right honourable friend for letting me intervene. The thing that people have missed, I think, over the last few weeks is the cross-party support for both the Windsor Framework and for this deal. And the reality is anybody campaigning or continuing to campaign against the decisions democratically taken by the Democratic Unionist Party are campaigning against something where this House has said in voting numbers I could have dreamt of when I was the government's chief whip during Brexit, that they support the Windsor Framework and they support my right honourable friends and the Prime Minister's deal.
Well, the right honourable gentleman makes an extremely powerful point, and I hope everyone will notice the near, if not complete, unanimity that we will see reflected in the House today. But those who wish to rail against reality and the fact we have to make choices, we have to deal with issues as they arise, as the right honourable gentleman for Lagan Valley has so eloquently pointed out, achieve nothing and contribute nothing. What the House is trying to do is to take this forward and, crucially, to restore the institutions. I will give way.
I'm not trying to rail against reality, I'm just trying to seek the truth. Would it be a fair summing up of the Labour Party's position that they're really supremely relaxed about all these trading arrangements in the future? Because if there is to be a Labour government, they've got absolutely no intention of diverging further away from the EU from a deregulatory point of view. So when if he becomes Secretary of State, there's no danger that any civil servant will say, well, Minister, be careful about this. So they are just very relaxed about this. They're going to get closer and closer to the EU, aren't they?
Well, it's very kind of the right honourable gentleman to say that we are intensely relaxed about the prospect that we might form the next government. And who am I to disagree with him in making that observation? The point about divergence is it's a choice. And what is very striking about what has happened since we left the European Union, one can see a number of instances where the current government decided, well, they were going to diverge, and then suddenly had second thoughts about it because it didn't really make a lot of sense. And I make no apology for having given the example of the veterinary SPS agreement we would like to reach, because it would help our businesses in the UK, it would help businesses in Northern Ireland, it would help businesses in the European Union. And that is my definition of common sense negotiation. The decision has been made, but that does not mean that Britain cannot seek to try and improve the relationship we have with the European Union in our interest and the interests of our European neighbours. Now, I also welcome the second part of Regulation 3, which would require a minister before the second reading of a bill containing provisions which would affect trade between Northern Ireland and the rest of the United Kingdom to either make a statement that it would not have such an effect, or to set out the reasons why the government wants to proceed nonetheless. Now, I wonder, it may be difficult at this stage, whether the Secretary of State in winding up could give us an example of the kind of circumstances in which ministers might want to make use of the provisions in 13C 2B at the top of page 4 of the regulations. In other words, that the government would want to proceed with legislation even though it would have an adverse effect. I welcome the clarifications that are made by Regulation 4 regarding any independent review that may follow the democratic consent vote. That vote by Assembly members must take place, as I understand it, by the end of this year. Has he had any discussions with Northern Ireland political parties as to when exactly that vote might take place, or does he intend to do so, or is it entirely a matter for them? Madam Deputy Speaker, I will return in the subsequent debate to the matters I wish to raise on the UK internal market regulations, but I will now bring my remarks to a close.
Obviously, there is a big time pressure on this debate. I want to bring the Secretary of State back in at 1:49. So I would urge colleagues to be brief if they possibly can. Chair of the Select Committee, Sir Robert Butler.
Thank you very much, Madam Deputy Speaker, and I certainly will bear that exhortation absolutely in mind, because I think although this debate has properly been focused on the statutory instrument that will amend primary legislation and change that primary legislation through the powers of the 2018 Act, which my honourable friend, Mr Skipton and Ribbon, and I both spent a lot of time dealing with in its enactment. I think it's right just to, just look again at what the helpful Annex A to the command paper outlines in terms of the history and the legal background to what the parties have been dealing with, and why it is that many of the arguments from the naysayers do not command, they don't pass close scrutiny at all. I'm delighted to see at page 53 of the command paper a very clear exposition of the position with regard to the Acts of Union. So the Acts of Union, because of course there was more than one in 1801, and since that time they have been amended, and not just by the seismic events of 1921. They were amended right through the 19th century, and indeed beyond that time, to take into account the evolving position of Northern Ireland. Just as every other part of our United Kingdom has evolved, so has Northern Ireland. And I think it's right to pause and say that arguments that were asserted, in particular in the Supreme Court, about the old, what we can now call the old protocol, being inconsistent with the Acts of Union, are just wrong, because that point was never at issue before that court. The court specifically said that they did not have to rule upon it. And of course, I'll give way to the honourable gentleman.
Much. A lot of this, however, is quite surreal, because it falls into the grounds of piffle. I remember sitting in the Select Committee in Northern Ireland, and the then Secretary of State from Northern Ireland, a member for Skipton, told me this will all be light touch. In October 2019, all light touch, you won't even notice it. And we've spent the last 4 years now trying to unravel the heavy hand and still need to prise the fingers of Europe off what's happening in Northern Ireland. And we've also been told, Madam Deputy Speaker, that yes, there was a problem, and we all now know what the problem was. The problem was this House failed to stand up to Europe and allowed Northern Ireland to be a buffer zone to protect their single market, and threw our single market down the toilet in the process. Hear, hear.
And I feel the emotion and the proper points that the honourable gentleman makes about this, because it became the legislative and constitutional equivalence of brain surgery. And the patient was Northern Ireland, and everybody was feeling it. This isn't just an archaic debate. This is a debate about business and the economy of Northern Ireland. This is real, and this is important for the businesses that honourable members and right honourable members represent. Absolutely right, which is why I think his party should claim proper credit for the painstaking approach that both he and his colleagues and the right honourable member for Lagan Valley have shown in this process. They haven't taken yes or no, rather, for an answer. They've actually sought to try and reach a solution and be part of that brain surgery process, that neurological change. But I'll just, gently say to him that there is, I think, a distinction between the integral part of Northern Ireland in our United Kingdom constitution and our single market, our internal market, and the inevitable access that Northern Ireland will have to the EU single market. Why? Because of the nature of the border that exists in Northern Ireland, the unique nature of its status, and all of the history and indeed the reality that goes with that. And that's why there's not going to be an elegant solution, a perfect solution to all of this. This is always going to involve compromise. Compromise is a difficult word. It implies weakness, it implies fudging, it implies a lack of clarity. But honourable and right honourable members opposite have recognised that that's the world in which they operate, which is why we're able to be here today to debate these important changes that will underpin not just declaratory words about Northern Ireland's place within the UK internal market, but concrete actions which are set out in the command paper. And I think in particular of the operation of the brake. Yes, we need to see more guidance about the operation of the Stormont brake. We need to understand the evidential thresholds that are going to be required for MLAs to bring the brake to the attention of the UK government, to lodge their objections. That work has got to be done. But today will allow that to happen. And I'll end on this note. As I was saying about the Supreme Court judgment, the court looked in particular at the question of the sovereignty of Parliament and affirmed, as Article 6 of the Act of Union itself recognised, that it is the most fundamental rule of UK constitutional law. Nothing novel or unexpected or controversial about that, Madam Deputy Speaker, which is why some of the language that then emerged from that case was not just unhelpful, it was wrong. And I know that the Right Honourable Gentleman, the leader of the DUP, shares that view. It was time for leadership, and leadership means being straightforward and getting it right. And that's why I commend him and his colleagues for the work that they've done, because they've got it right. And as a result of their approach, we are able now today, I hope, to pass this much needed change. I welcome it warmly. I commend my right honourable friend, and I commend this measure to the House.
SNP spokesperson Richard Thompson.
Thank you, Madam Deputy Speaker. Now, I and my party have never made any secret of our disagreement with Brexit and the manner in which it was delivered. That's certainly something which has caused issues for us in Scotland, but we broadly welcome the point to which matters have reached today. It's been a long road to get here. Having clarity around about Northern Ireland's constitutional status is, I believe, helpful, as indeed is the reaffirmation of the principle of consent, which is the basis that many of us in Scotland, not just in Northern Ireland, understand the union that we are willingly or otherwise a part of. Now, the manner in which Brexit has come about has certainly caused issues in Scotland and has placed our own constitutional question right back in the fore and under renewed scrutiny. But despite the tensions that has released politically, or brought about politically, I hope that my party and I have been able to understand and at least empathise with some of the concerns of people in Northern Ireland, not just over how Brexit, as originally constituted, threatened to undermine the basis on which peace and progress had been secured over the previous quarter century, but I hope that my party and I have also been able to understand and reflect wherever we could how aspects of the protocol had left unionists in Northern Ireland in particular feeling that they'd been in some way separated or been set in a course of being separated from the UK. And in that regard, I've always said on a number of occasions, we never considered it unreasonable in and of itself that in light of experience that the UK government should seek to try to renegotiate aspects of the deal or to rework aspects of the deal that had been put in place. And while there were certainly opportunities to recast a deal which could have worked better, I would argue, in the interests of all parts of the UK, and I would highlight sanitary and phytosanitary alignments as being essential to that. And I very much regret that those options have not to date been pursued. I should just say that I do not grudge Northern Ireland a single aspect of what has been agreed in recent days or what appears in the SIs before us today. There is, however, something that looks like a I will, yes.
Just on the point where he's not begrudging us for achieving some of the objectives that we set out to achieve, would he agree with me that one of the advantages that we have that Scotland doesn't have is that we have a 300-mile unclosable land border, which makes virtual accommodation with the access into the Irish Republic and onwards into the wider EU market almost impossible to prevent?
Well, yes, I mean, certainly the border is a very complex one to try and police, and that has certainly been at the forefront of many of the discussions. And so in contrast, we've got a very straightforward one between Scotland and England, were that ever to take on international significance. But I appreciate the point that the honourable gentleman is making. Now, I would just say as briefly as I can, there appears to be something of a contradiction in that Northern Ireland cannot conform to the requirements of the single market to maintain access there, and also the UK internal market in the event of a future divergence. That's brought to mind in paragraph 146 of the command paper that the government will legislate to require that a minister in charge must assess whether or not something has an impact on trade between Great Britain and Northern Ireland and make statements. In contrast to 38A1 of the SI, that HMG must not ratify an NI-related agreement with the European Union that would create a new regulatory border. Now, a minister might lay a statement before Parliament to that effect, but that doesn't mean that the minister's opinion will necessarily be shared or make that statement any less subjective. And, you know, ministers might be capable of thinking 6 impossible things before breakfast. Indeed, at times during the Brexit debate, it seemed like that was a necessary qualification for office. But nevertheless, I would be grateful if the Secretary of State, in his summing up, could clarify how any such dispute over that might ultimately be determined and resolved. So, with these publications, Madam Deputy Speaker, we appear to have reached something of a conclusion. It's been a thoroughly exhausting process. It's occupied talents and energies, not just in government and in Parliament here, but across swathes of public life in Northern Ireland and beyond, that could have been directed, I would say, more productively. But much work is built up in the absence of an assembly. Hopefully this will now allow all the political mechanisms to go in place to bring that back, and it is important that that now happens because, Madam Deputy Speaker, a peaceful, prosperous Northern Ireland at ease with itself, in control of its future, and which is able to be respectful of all shades of opinion, is manifestly in the interests of all peoples in all of these islands. And to the extent that the statutory instruments before us today allow a way to pave a way to restoring that state of affairs, we support them. Thank you.
And let me once again emphasise the need for brevity to get the majority of people in. Sir William Cash.
Thank you, Madam Deputy Speaker. Section 38 prescribes that parliamentary sovereignty will prevail, and that is notwithstanding Section 7A, and in the wording, which is a bit difficult to read because you have to go through all the enactments to make sure you've got it right, it does say including the Windsor Framework. So for practical purposes, our parliamentary sovereignty subsists. However, I do find it incongruous and rather Lewis Carroll that we should end up by continuing to maintain EU law in relation to Northern Ireland. I could make a long speech about this, but I won't. The fact is that no man can serve two masters, and as respects the wording of the statutes, to use the words of Humpty Dumpty, words mean what you choose them to mean. The question is who is to be master, that is all. And this is the problem, this is the dilemma, this is the basis on which most of the controversies occur, and it may be, I regret to have to say, that this will ultimately be decided someday in the future by the prospect of a referendum, and that is, of course, is what Sinn Féin have been asking for. And I personally believe that we should protect Northern Ireland, and I've always done everything in my power to do just that. But having said that, and also mentioning that my family have been involved in the Irish question since the 1840s in this House, John Bright, Frederick Lucas, member for County Meath, and so forth. I just make that as a point. I take this very seriously, as indeed I pay respect to the members of the DUP for the way in which they fought for their interests. There are some things in here, in these measures, which I can understand as having benefit, But I do say that ultimately the question is going to turn on the issues of whether or not in the constitutional framework within which this is presented, with all the assurances that we're being given and all the hopeful aspects of it, which I expect to be delivered, we will find that it will be decided by the test of time. We will see whether it works. There will be continuing arguments and there will be continuing debates. But unfortunately, I have to say that just as under Section 2 of the 1972 Act, the European Communities Act, there is no way in which regulations under Section 8C have anything other than the same fundamental limitation as regulations under that section, in that they cannot contradict or restrict the scope of EU law. It has to be said because that is the honest truth. However, that does not alter the fact that efforts can be made. The Stormont break may come in. It may be able to make changes. I say everything with reservation because I voted against the Windsor Framework because I foresaw that issues were going to arise of this kind. I have to pay tribute to all the people involved in trying to mitigate the ultimate impact of the Windsor Framework, but it still leaves me with a very serious sense of concern for the very simple reason that I've just given. The scope of EU law still remains, and as Chairman of the European Scrutiny Committee, and I think I can bring my remarks to an end on this note, we will be monitoring this. We are concerned, I am concerned, and I know that under the new arrangements, and I'm glad that the devolved assembly is going to take place, this is a democratic plus. You can't just issue orders from Westminster to Northern Ireland if the people don't want it. And the bottom line is the DUP have got a real issue on their hands with Sinn Féin. But be that as it may, I genuinely believe that they will do everything in their power to maintain their own democratic rights. I'll give way.
I'm very grateful, Madam Deputy Speaker, to the Right Honourable Member and my friend, Chairman of the European Scrutiny Committee, and he has outlined his concern about the constitutional future of Northern Ireland. And he will know legislatively that in 1998 it was settled that the future of Northern Ireland's place within the United Kingdom is based solely upon the decision made by the people of Northern Ireland. He will remember that in 2000, Gerry Adams said that there would be United Ireland by 2016. And he will know that as we stand here today, in 2024, the government that will have to make the decision as to whether there should be a border poll has just declared in this command paper, Safeguarding the Union, page 68, paragraph 3. On the basis of all recent polling, the government sees no realistic prospect of a border poll leading to a united Ireland.
Hear the honourable gentleman make that point, and I would simply say, in conclusion, you can read the crystal ball. The question is, can you always read the book?
To Geoffrey Donaldson.
Thank you, Madam Deputy Speaker. It's an honour to follow the Right Honourable Member for Stone, who we truly value his continuing interest in Northern Ireland. Of course, Madam Deputy Speaker, the problem for us on this bench is that the origins of our difficulty was the withdrawal agreement itself and the decision to go with the Northern Ireland Protocol, which sadly placed Northern Ireland in a situation where we were separated from the rest of the United Kingdom in key elements of the benefits that ought to have flown from Brexit. And my task, and that of my colleagues ever since, has been to repair the damage that decision did. And it is work in progress. I do not stand here this afternoon and pretend that we have completed the task. I recognise that there are ongoing concerns about how these new arrangements will work in practice, and it will be our task to hold the government to account on its commitments, that they are honoured in full and delivered, and that is why my party executive mandated me as my as the leader of the party, to proceed on the basis that we needed the government to progress key elements of these arrangements first, before we would then proceed to recall the Assembly and to restore the Executive. And so, Madam Deputy Speaker, I welcome the publication and the opportunity to debate these statutory instruments today. They amend laws, key constitutional laws of the United Kingdom, in my humble opinion, in a way that strengthens Northern Ireland's place within our United Kingdom, reaffirms our place in the United Kingdom, underpinned by the Acts of Union, underpinned by the principle of consent that is at the heart of the Belfast Agreement and the 1998 legislation, and that is to say, as my honourable friend, the member for East Belfast, has stated, it is the will of the people of Northern Ireland that will ultimately determine our future. But nevertheless, it is welcome that this Parliament, that is sovereign in our United Kingdom, reasserts its sovereignty in regard to Northern Ireland and reaffirms our place within the United Kingdom.
On that point, can I thank my right honourable friend and colleague for bringing that forward. And the right honourable gentleman is absolutely right to state the fact I say this with respect to the Secretary of State and the Government, the distrust that many unionists have for this process. The opinion of this House and sovereignty should be clear, and I can say that my party leaders sought not simply to secure the legislation and change for this to take place, but to future-proof it. The difficulty is that many people that I represent have stated their lack of trust in the government, which told us they would give us their best and didn't. So how can government and how can the Secretary of State reassure the unionist people that we represent that this here, our sovereignty, is protected?
Well, I thank the honourable member for Strangford for his intervention, and he restates the point he made earlier to the Secretary of State, and he will have heard the response given to this to him by the Secretary of State. But it is our task, those of us on this bench, all of us on this bench, it is our task to ensure that the government does deliver, that we bank the gains that we have made in this process, and that we move forward on that basis, recognising that there is more to do, but also recognising that there are new opportunities to seek and to secure change. The Secretary of State referred earlier to my detractors who have been very vocal. Indeed, they even challenged me to a debate on these issues. But my challenge back to them is clear and simple. As I said last week in this House, when they are in a position to set out clearly for the people of Northern Ireland what they have achieved, the changes they have secured to the protocol, the changes they have secured to the Windsor Framework, the changes they have secured to safeguard our place in the Union, I'll consider discussing with them. But what I will not do, Madam Deputy Speaker, what I will not accept is their criticism of what we have achieved in terms of safeguarding the Union. Real achievements, real changes, changes that my party has long sought. We were disappointed when the government abandoned the Northern Ireland Protocol Bill, because all of us on these benches, all of us, recognised that those proposals provided a way forward for Northern Ireland. And what we have sought to do is to incorporate into these new arrangements many aspects of what was in the Northern Ireland Protocol Bill. But we've gone further, and we've achieved more. Because in the Protocol Bill, the proposal was, and we will come to this, Madam Deputy Speaker, more fully in the second statutory instrument before us this afternoon. But the Protocol Bill, endorsed fully by my party, my parliamentary party, proposed a green lane and a red lane. as the means by which goods would move between Great Britain and Northern Ireland. What we have achieved is to remove the need for the Green Lane, because we have restored Northern Ireland's place within the United Kingdom's internal market. And under these new arrangements, goods moving from Great Britain to Northern Ireland and staying within the United Kingdom will flow through the UK internal market system. There is no need for a so-called green lane. There's only a need for one lane, and that is the lane that deals with goods flowing through our Northern Ireland ports and onwards to the European Union, or are deemed at risk of entering the European Union. The red lane was endorsed by my party. The red lane was supported by my party. And every one of my MPs voted for that proposal. And that was my mandate. And it's what I have secured. And that removes the Irish Sea border within our internal market of the United Kingdom. And it means that the only checks that we need to carry out are those on goods moving into or at risk of going into the European Union. That is what we stated when we set out in our response to the Windsor Framework, endorsed unanimously by all of our party officers, all of them, endorsed our response to that framework, and we made clear what we wanted, and I have gone further, even than that response, in removing the Green Lane from the new arrangements. So this is progress. Does it give us everything we want? It doesn't. The Honourable Member for North Antrim has been assiduous in his pursuit of a solution on veterinary medicines. He has worked with the government, campaigned alongside the representatives of our agri-food sector in Northern Ireland, and as a result of that work, in this command paper, we now have clarity on the position of the UK government, that in the absence of an agreement with the European Union that maintains Northern Ireland's full access to UK veterinary medicines, the UK government will legislate to protect our access to veterinary medicines in the United Kingdom. And that is a commitment given by the government, and I commend the Honourable Member for North Antrim for his work. That's the business we're in. It is unfinished business, and we will continue to work to ensure that the government delivers on its commitments in this command paper on veterinary medicine. Of course.
Thank the Leader of the Party for his comments there. Look, this is a crucial thing. It affects every single person in Northern Ireland because it's about food security across the whole of the United Kingdom. Northern Ireland's food industry feeds about 17 million people, not only in Northern Ireland, but across the kingdom and across the world. It's vital to our food security, and damaging it, which was happening under the previous agreement, is wholly destructive to food health and to farming. But I also want to welcome a point that has been made here with regards to the movement of cattle and livestock. I noticed that under paragraph 22, that matter has been addressed, and that is very significant for our farming industry. And I do agree, more needs to be done. I'll hold the Secretary of State to account, get that legislation on the book if Europe doesn't move.
Madam Deputy Speaker, I thank the Honourable Member for his intervention. I need add nothing to the point he has made. We welcome the explicit reference to Northern Ireland's part in the economy of the United Kingdom within the command paper, including the fact that we are within the customs territory of the United Kingdom. We are part of the UK internal market, and it is important that that is maintained.
Very grateful for the Right Honourable Member for giving way. Can I just put on record that I think he has done a lot of good work over the past couple of weeks, and he's been very brave. It's not an easy thing to do, to face down people within your own constituency, and I think it's important that he did it. But can I also put on record that the SDLP don't support this command paper, actually. We think it has moved far beyond the principles set out in the Good Friday Agreement. It is undermining North-South cooperation, and it's far too much focus on East-West. And I would just say that moving on from this point, we need to ensure that any future negotiation is done with all parties and both governments, so everybody can feel comfortable in the result.
Thank you very much. Well done. Thank you.
Madam Deputy Speaker, the honourable member for Foyle has made his point with fortitude and determination, but he will understand that I make no apology as a unionist for having a focus on protecting, preserving and strengthening and binding together our United Kingdom, of which Northern Ireland is a proud part. And today is an important moment for us as unionists. The strengthening of our constitutional position within the United Kingdom is important because our primary focus has been on the protection of the Union. And in that context, I want to welcome and draw attention to Annex A, paragraph 47 of the command paper published yesterday. Northern Ireland, and I quote, "Northern Ireland's place in the economic union remains the single most important factor in ensuring its prosperity." And that is the economic union of the United Kingdom, where we sell more goods to Great Britain than we do anywhere else in the world, and we want to maintain our ability to trade freely within our own country. And these new arrangements, Madam Deputy Speaker, guarantee our unfettered access to the internal market of the United Kingdom, not just for now, but in all scenarios in the future. And the safeguards that are built in to these arrangements, I believe, will protect our place in the economic union of the United Kingdom. I give way.
Right to one gentleman for giving way. I echo completely his sentiment of paragraph 47 there in Annex A, and I'll just comment that the goodwill and character that has been essential to achieve this progress and these gains through these last months. But does he agree with me that the polling referenced by the honourable member for East Belfast is not as important as the stamp of approval from this House that comes through good debate and scrutiny?
I thank the honourable member for his intervention and for his continuing interest in Northern Ireland and his work in this place to strengthen and protect our union. And he makes a strong point which I welcome. I will give way.
Acknowledging the point which my colleague makes, would he also accept that in 13C of this bill, the government still reserves a right to introduce laws which will interfere with trade in Northern Ireland and to put those laws in the statute book?
Well, I would urge the honourable member for East Antrim to read all of the proposals, and if he does, he will see that there is a new statutory duty to be introduced in law that will ensure the government of the United Kingdom, in circumstances where there is the risk of divergence, the minister in charge of whether it's a new policy or a new law will come to this House and make a statement, not only informing the House of any potential impact on Northern Ireland's place within the United Kingdom internal market, but set out the measures that the government must take to ameliorate that situation. And that is clearly in the command paper. That is a clear commitment from the government, and that is one we intend to hold the government to account on, because it is important going forward, not only that we have a means of scrutiny and of cutting as we have through Section 7A, the amendment. This is so important. The amendment, people told us, by the way, Madam Deputy Speaker, that we would not achieve legal change. And yet the amendment to Section 7A cuts the EU pipeline, ends the automatic alignment of Northern Ireland with EU law, and that is something this party can take great credit for, because we have achieved what none of our detractors have been capable of achieving. And that offers us the opportunity then to influence clearly, as we stated in our 7 tests, how we might proceed. In conclusion, Madam Deputy Speaker, on behalf of my party, may I welcome this legislation this afternoon. It is important constitutional legislation that I believe safeguards our place in the United Kingdom, and we will hear a little later about further changes to the law that will protect our place in the UK internal market, and taken together with all of the proposals in the command paper, I believe we have a basis for moving forward.
Smith.
Pay tribute again to the Nationalists and other parties who have been patient during this process, and to the Labour Party for the government support, and to my Secretary of State and the Prime Minister. These are very important safeguards, constitutional safeguards, as we have heard. But this SI is about much more than the Constitution. It unlocks something much bigger, that is getting back into Stormont, making Northern Ireland a success and making it work. This constitutional SI is about people, it's about public sector pay, it's about health, it's about charities desperate to get moving again, it's about schools, it's about agriculture, and it's about the economic growth of Northern Ireland. I commend this SI and believe it will get the full support of this House.
Secretary of State.
Madam Speaker, with the leave of the House, I'd just like to answer a few of the points that have been raised. We've heard a wide range of varied range of contributions on all aspects of the regulations from members across the House. And in my closing remarks, I'd like to take the opportunity, Madam Speaker, to address those points. Firstly, if I may, thank the Honourable Gentleman from Leeds Central for the way he's approached everything we have done. Again, I thank him very much for it. He I did ask a few questions. I'll try and answer. He actually talked about these measures and how we will be protecting the European single market with this package. What these measures also do, which is unbelievably important, is protect our own internal market at the same time. And so I know he knows this, but I just wanted to emphasise the point because it is a very important one. He asked me for an example of where I think it's clause 13C, where there'd be a significant adverse effect, and I can only refer him best to the one I gave in the Animal Welfare Livestock Exports Bill, where there is an obvious advantage to Northern Ireland and to be different, which we did take on board. And he very kindly showed some ankle on Labour's position on our future relationship with the European Union. And can I beg him to continue to do that? Because I think he will find that whilst we all enjoy a good political debate, and I won't go too far into this point because we're on a consensual place, but we would very much like to explore exactly what Labour's position on the European Union, free movement and a whole host of other things would be, and I give way to the Honourable Lady.
Member for giving way, and he makes reference to the fact that within the legislation there now is this safeguard around significant disadvantage to Northern Ireland and the significant adverse effect. Yet the significant adverse effect, would he not agree with me, is actually very subjective, has no concrete definition, and actually the section under it, section B, allows a minister to just go ahead anyhow, even if it does significantly adverse effect.
I thank the Honourable Lady for her question, and actually before I answer it, can I just say I owe the Honourable Lady an apology because I misheard her question yesterday completely, and I was having trouble with hearing, I think it's my age, but it might have been a microphone, I hope it was a microphone, and so I just wanted to apologise for not answering her question properly yesterday. I disagree with her, and I think a written ministerial statement allows this place to scrutinise what a minister is doing and be more transparent about it. I also wanted to make a point, and I hope I'm not going to punch a bruise, about the member, some of the things in contribution and intervention on the member for Leeds Central from the member from Northampton. He said in an intervention to the member for Leeds Central that tariffs between GB and NI would be acceptable if they were the will of the Parliament. So, I mean, I disagree. I think a £3 tariff on Bushmills wouldn't be that great. But all of the arrangements in the Windsor Framework are given full effect by the will of this Parliament. And so, by his definition, must be completely acceptable. And so I thank him very much for his support, and I beg to move.
The question is the motion on the draft Windsor Framework Constitutional Status of Northern Ireland Regulations as on the order paper. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. We now come to the second motion on the United Kingdom internal market, and I call Minister Steve Baker to move motion number 2 as on the order paper. Debate on the motion can continue for up to an hour and a half.
Thank you, Madam Deputy Speaker. I beg to move that the Committee of the Whole House has considered the draft Windsor Framework UK Internal Market and Unfettered Access Regulations 2024. It is the view of the Government, and I believe the overwhelming number of honourable and right honourable members across the House, that the Union ought not to be reduced to matters of the law or the Constitution alone. Ours is a thriving economic, cultural and political union whose health is ensured in no small part by the free flow of trade across it. Enhancing that economic aspect of the union is the purpose of this second set of regulations before the House today. The views of businesses and traders on the progress we have made here are also important in the context of today's debate. I'm pleased to confirm that the early reaction from business has been promising. A collaboration of 14 key Northern Ireland industry bodies yesterday were clear in saying that they welcome this agreement. Madam Deputy Speaker, the Government is very clear that the old protocol created unacceptable barriers within our internal market, and I would invite anyone to consider the full implementation of the old protocol against what we have achieved in the Windsor Framework. The Windsor Framework makes major steps forward, and I do want to acknowledge that this is first and foremost an achievement of the Democratic Unionist Party, and also a great achievement of my right honourable friend, the Secretary of State. The framework restored the functioning of the UK's internal market by ensuring the smooth flow of trade within the UK and disapplied a range of EU law, including ensuring that Northern Ireland benefits from the same VAT and alcohol taxes as the rest of the UK. Members of this House can also be encouraged by the smooth functioning of the framework since October 2023, when the first phase of arrangements came on stream smoothly, supporting trade between GB and NI. And I should just say, colleagues did ask me, how's it going? And I said, have you seen any news on it? And of course, no one has. It's been going very well, and I want to thank and congratulate all those officials here and in Northern Ireland who've made that possible. These regulations now go further in that aim to strengthen our UK internal market, now and in the long term. Following the agreement of the Windsor Framework, the Border Target Operating Model sets out that we will begin phasing in checks and controls for Irish goods and non-qualifying goods moving from the island of Ireland to GB from the 31st of January, indeed from yesterday. This is a powerful demonstration of Northern Ireland's integral place in the UK's internal market, and it rebuts incorrect claims that it is a member instead of the EU single market. The reality is that third country members of the EU single market will now have full third country processes applied, while Northern Ireland's businesses have full, unfettered access to their most important market in Great Britain.
Madam Deputy Speaker, he is absolutely right. And perhaps the most powerful illustration of the change we have secured is to consider what will happen now on the ferry route between Dublin and Holyhead as a result of these new arrangements. A Northern Ireland haulier using that service will board the ferry, travel to Holyhead, leave the ferry and travel straight out of the port on to their destination with no customs procedures and full unfettered access. In contrast, a Southern Irish haulier arriving at Holyhead will be subjected to full UK customs procedures at the port before they can proceed. And does he join me in welcoming Northern Ireland's restoration fully within the UK internal market?
Yes. Madam Deputy Speaker, he's absolutely right in what he's just set out, and I do join him. It is a proud day for me, as it is a proud day for him, and I want to join other members in congratulating him on his courage in bringing us all this far. As a result of these regulations, this now includes guarantees for Northern Ireland goods moving to the rest of the UK via Dublin, as he says. This unfettered access is future-proofed, ensuring that it will persist in the future, regardless of how rules evolve in either Northern Ireland or Great Britain. These regulations will more squarely focus the benefits of unfettered access on Northern Ireland traders. The regulations both tackle avoidance of the rules and ensure that for agri-food goods to benefit from unfettered access in avoiding SPS processes, they must be dispatched from registered Northern Ireland food and feed operators. We will also expressly affirm through these regulations that export procedures will not be applied to goods moving from Northern Ireland to other parts of the UK's internal market. I will.
Can he explain that with goods moving from GB to NI, it's said that maybe 80% will be able to use the internal market lane. Why would 20% not be able to do that? And why wouldn't the UK government, who I was told were in charge, want to ensure practically all goods use the internal market lane?
Well, with great respect to my right honourable friend, with whom I've gone a very long way in this cause, I think possibly he might like to revisit the text, because the point here is that 80% of the goods going on that route are staying in Northern Ireland. They are UK goods. The 20% are goods which are going on to the European Union. And that's the point. It's 80% UK internal market trade, 20% trade going on to the European Union. And I will. I can't say that I'm astonished. This is the important moment.
Would he accept that, first of all, 20%, even all the statistics show at the moment, 20% of the trade which goes through Northern Ireland does not go to the Irish Republic. In fact, it's about 0.1 or 4%. But much of that trade, which will go through the red lane, are goods going into Northern Ireland, either to warehouses or to manufacturers in Northern Ireland, and might never go near the Irish Republic at all, might stay in Northern Ireland, go back to GB, or go to the rest of the world, but yet will still be subject, Northern Ireland products still be subject to checks going into Northern Ireland.
Madam Deputy Speaker, I wouldn't accept that, no. I mean, I'm not in a position now to set out the statistics. I don't doubt that the statistics need some work applied to them. But it pains me to say that, you know, I've always regarded him as a great friend, and he and I have walked a long way together on this. I've always regarded him as an ideological bedfellow, both on the Union and in relation to Brexit. But I think it does have to be said, as his leader said earlier, that we voted for the protocol bill. We fervently supported the protocol bill. We said we were willing to have a red lane. We were willing to have a red lane in order to safeguard the legitimate interests of our friends and partners, family members, as the Irish ambassador Martin Fraser, just one moment, as Martin Fraser said, this is always a family dispute, and we're always going to get through it. Well, they have, I will give way widely in a moment, our friends in Ireland, and indeed in the EU, have legitimate interests which we should have the humility to respect. And even if we had acted as a single, united Parliament, unilaterally with the protocol bill, if we had ridden roughshod over any international negotiation and just done what suited ourselves in that protocol bill, we would have implemented the red lane. And I'm afraid I will part company now with anyone who says otherwise. We would have implemented the red lane, even acting unilaterally, out of respect for the legitimate interests of our friends and trading partners, and it was right that we should do so. I give way first to the DP leader.
Will the Minister join me in welcoming the announcement made on Tuesday, where there is agreement on a joint legal text which will significantly change the status of goods coming in from the rest of the world into Great Britain and travelling on to Northern Ireland, and that the effect of this change, which is part of these arrangements, part of the command paper published, will be that some 4 million goods movements between Great Britain and Northern Ireland will now be out of the red lane and into the UK internal market system, and that's this party delivering and securing real change that ensures more and more goods flow freely between Great Britain and Northern Ireland, save for those going into the EU or at risk of going in because they're part of a manufacturing process of goods being sold to the EU.
Yes, Madam Deputy Speaker, and I welcome that intervention very strongly. I thought he was going to go on perhaps to mention the draft joint agreement on TRQs, tariff rate quotas, because for a while I was concerned that TRQs needed to be applied to Northern Ireland so that Northern Ireland could share fully in the full benefits of free trade agreements with the rest of the world. And I perhaps hope to return to this later, but in case I don't have the opportunity, what an extraordinary situation Northern Ireland is now in. Northern Ireland is not in the single market, and I draw anyone's attention to page 4 of the command paper, which sets out these check marks comparing Northern Ireland to Ireland as a member of the EU and to Norway as a member of the single market through the EA, but not in the Customs Union or the European Union. Just to see that Northern Ireland really does have the absolute minimum of EU law compatible with unfettered or privileged, perhaps, goods access to the EU market, consistent with having an open infrastructure-free border. And I do wonder at people who thought, I will give way, I promise I will, I do wonder at people who thought that we could leave the European Union and establish a hard border, or leave the European Union and do absolutely nothing about the border. We were always going to leave the European Union and have special arrangements in relation to Northern Ireland. And this is a moment of great feeling for me, because even before the referendum vote, I and other colleagues set up a committee of Eurosceptics to consider how we might deal with these issues. But I confess we did not have the SPS and customs expertise to proceed, and that then became the great story of this battle. I don't doubt that if the United Kingdom had united in accepting the result of the referendum, if this Parliament had united in going forward with resolve to further our own interests as a nation-state independent outside the EU, but crucially also with the humility to respect the legitimate interests of our friends and partners, if from the beginning we'd had united resolve, clarity of vision, I do not doubt that in a spirit of friendship, the kind of spirit of friendship and goodwill which today exists, thanks to the work of my right honourable friend, the Secretary of State and the Prime Minister and others, the goodwill that exists between Ireland and the European and us, between the European Union and us, we are now in a totally transformed position to make a way forward as friends, respectful of their interests, resolved on our own. But that is not what happened. You do not need me to rehearse it, but we have had 8 years of drama for us to arrive at this moment where we have reduced EU law to this extent and where we have put in place a red lane to protect the legitimate interests of Ireland and the EU. That is something that I think we should all be very proud of after everything we've faced and all of the risks that could have put us in a far, far worse position. I gladly give way.
Thank the Minister for giving way, and I want to just come back on one area, and I appreciate and understand totally why the benefits and the need of having the red lane to ensure goods that are going into the Republic of Ireland are checked. But where I do have a difficulty is where I have a business in Northern Ireland where 98% of their sales are into Northern Ireland, and it all comes in one container load of stuff to them, and maybe 2% of that load might make its way into the Irish Republic as part of a service agreement that they might well have with another dealer. I'm talking about a major firm in my own constituency which have an all-Ireland approach. That means every single item, even though 98% of their stuff is used either in Northern Ireland, Scotland or England, they are a main distributor, and as a consequence they are going to end up with having to put all of their goods through that. I do understand that a job of work might need to be done to try and ameliorate the problems they have with some of those areas.
I'm most grateful, and he is right that a job of work will need to be done, and I can assure him, my right honourable friend the Secretary of State just said of course it does. He's right that there's going to be further work to do, and I am grateful that as we seek to do that further work, we shall be doing it in a spirit of goodwill and cooperation through the Joint Committee with the European Union, and I certainly would be very glad to visit that firm, perhaps with him if he wishes. If he drops me an email to my NIO address, I should be glad to visit the firm with him and bring officials, and we'll see if we can move further to assist them. But, you know, I just need to find out more about their exact circumstances. I'm very grateful to him. I lose track if anyone else wished to give way. I think I'll press on. My goodness, that was a long series of interventions. The legislation ensures we can avoid any unnecessary gold plating in the implementation of new arrangements through new statutory guidance on Section 46 of the UK Internal Market Act 2020, setting out how public authorities should have special regard to Northern Ireland's place in the UK's internal market and customs territory and the need to maintain the free flow of goods NI to GB. We will take a power through these regulations to issue such statutory guidance, and public authorities will be required to have regard to it. These changes to the law will help ensure that public authorities take every proper effort to prevent new barriers to intra-UK trade. In doing so, they will, in the long term, maintain and strengthen the health of the UK internal market, which I'll gladly.
Mr. State, for giving way. Mr. State, one of the things that greatly vexes us on this side has been the issue that the farmers in my constituency, indeed in our constituency, have told me about the vets cost even more as they have to source medicines and devices from an acceptable source. Reading from the command paper, which we have in front of us, this issue has not been resolved, but they say it will be worked on. The question I must ask is whether this is a firm demand on government or whether it is just another working group that will talk about things. I know the Honourable Member for North Antrim has been very much to the fore of this. I think we need some person on that committee to push things forward. I think if we have a solution which is through the committee, I think we need to see a timescale for delivery. Thank you.
Madam Deputy Speaker, we understand that point and we absolutely are listening to him and others, and I can tell him we are absolutely resolute that of course Northern Ireland must have proper access to veterinary medicines, and we'll of course be glad to work with him and others. He will appreciate that priorities are what they have been, and we will certainly continue to make now pursuing veterinary medicines a very high priority. I'm personally resolute on the issue, and I look forward to pursuing it with him and others. These regulations must be seen in the context of this overall package which has been agreed between the Government and the DUP. The passage of these regulations demonstrate the Government's commitment to taking forward that whole package and to maintaining the participation and trust of the whole community in Northern Ireland's political processes and the Stormont institutions going forward. And I would just, if I may, touch on what the Honourable Gentleman for Foyle said earlier. I absolutely, and my right honourable friend the Secretary of State, the whole government is completely committed to the Belfast Good Friday Agreement in all of its dimensions. But as I said myself to one nationalist politician, possibly about a year ago now, if I recall, it's perfectly possible to be a unionist and support the Belfast Good Friday Agreement in all its dimensions, just as it's possible to be a nationalist or a Republican and support the Belfast Good Friday Agreement in all of its dimensions. And, you know, that is, in a sense, the beauty and the triumph of the agreement, that we can all support it and move forward. But I can understand, I try and say this as gently as possible, I can understand the degree of discomfort from the Honourable Gentleman, because, of course, this is a big breakthrough for unionism. A unionist Conservative government has agreed to do unionist things with the Democratic Unionist Party, and that is something I am very proud of indeed. But that does not in any way diminish our impartiality. It doesn't in any way diminish our commitment to governing or seeing to the government of Northern Ireland in a proper manner. And I would just say to him before I give way, I think that after the experience of the last 8 years, perhaps 14, I need defer to no one in my vociferous commitment to democratic self-determination.
Well, I thank him for giving way. He says he supports the Good Friday Agreement in all its parts. Does he support the bit that says that the government should be rigorously impartial?
Yes, I am. No,
and I don't quite hear the Leader of DUP's comments. Well, it has long been said that this is the Conservative and Unionist Party, and we have long been understood to be a Unionist Party. And this agreement is entirely consistent both with our unionism and with our full respect to all dimensions of the Belfast Good Friday Agreement. And, you know, we will continue to govern in a spirit of goodwill and impartiality. And I will, and then after I've given way to my right honourable friend, I will just, I think, make progress and finish so other colleagues can have theirs.
I'm very grateful to him, and I'm listening very carefully to the interventions from the Honourable Member for Foyle and the concerns that he and others will have about the scrapping of the legal obligation in regard to the all-island economy. But isn't the point this, that as a UK government, we have to uphold the rules that apply within our United Kingdom and the promotion of our own internal market, but that doesn't detract from the question of access to the single market that Northern Irish businesses will continue to enjoy. And that's the compromise that has been reached here. And therefore, there isn't a binary choice here or either or. The concerns of the Honourable Gentleman for Ford can largely be met and continue to be met in a way that is in full accordance with the Good Friday Belfast Agreement.
I agree with my right honourable friend, and he demonstrates his expertise. But look, I look forward as much as anyone to the re-establishment of the Assembly and the Executive, and along with that, the re-establishment of the North-South institutions. They're much needed, and I look forward to their work, and I don't mind admitting that I find myself able to work constructively with politicians of all political parties in Northern Ireland, and I'm glad to do so. Let me return then in concluding to what is at stake in this process. I firmly believe that all parties in this House and all parties eligible to form part of an executive want Northern Ireland to work. I've seen what unites political leaders in Northern Ireland, a real determination to make life better for their constituents, and my goodness, on a wide range of fronts, that is necessary, and to allow Northern Ireland to grasp the opportunities of the future, and what an opportunity it is. I elaborated some of the things which Northern Ireland has before it right now. If you combine the institutional arrangements before Northern Ireland with the very substantial financial package to transform public services and to deal with the public finances, if Northern Irish politicians reach out and grasp the opportunity which is now before them, my goodness, they can make Northern Ireland a beacon to the world, a beacon of prosperity, I hope a beacon of reconciliation, and these regulations today are part of that process, and I commend them to everyone in the House.
The question is the motion on the draft Windsor Framework, UK internal market and unfettered access regulations as on the order paper. Shadow Secretary of State Hilary Benn.
Thank you very much indeed, Madam Deputy Speaker. Can I begin by agreeing with the Honourable Gentleman, the Minister, when he says that businesses in Northern Ireland want to make the current and the future arrangements work, and they want them to work well, and that there is huge potential for the people of Northern Ireland and the economic benefits that its current and future circumstances provide it with. I've got to some very specific points about the regulations, which, well, he's clearly relishing responding to those. Turning to paragraph 81 of the command paper, it says, and I quote, "We are now changing the arrangements to ensure that checks are eliminated, save for those conducted by UK authorities needed for the protection of the UK's internal market on a risk and intelligence basis." Can he just clarify which checks on goods moving from Great Britain to Northern Ireland are going to be got rid of? Is he referring to identity checks or checks on paperwork or something else? And as we know at the moment, up to, well, about 10% of goods using what's called the Green Lane that will become the UK internal market lane are subject to some checks on paperwork. Could you just clarify what is going to happen to those? I welcome the amendments to the UK Internal Market Act provided for by Regulation 2. The proposed new Section 45A of the Act would reaffirm Northern Ireland's unfettered access to the rest of the internal market and ensure that no new NIGB checks can be introduced. Regulation 2 also makes provision for the Secretary of State to issue guidance to departments on how they should carry out their duties under Section 46 of the Internal Market Act, namely ensuring they have special regard to, among other things, Northern Ireland's status in the UK's internal market when formulating policy. Can he confirm that guidance will soon be forthcoming and share any further details he can at this stage about what it will contain? I note the changes to the definition of Northern Ireland qualifying goods EU exit regulation made by Regulation 3, which are intended to prevent Northern Ireland from being used as a backdoor for EU goods moving into GB and also to protect Northern Ireland's agricultural sector. Ensuring that NI-registered agri-food operators fully benefit from unfettered access is a very positive step, and I welcome it. Can he tell the House whether any further changes to the definition of qualifying Northern Ireland goods are envisaged by the government? I also note the government's confirmation in the command paper that there will be no border control post at Cairn Ryan, which is to be greatly welcome. But could he say anything further about how checks and formalities on non-qualifying goods entering GB from Northern Ireland through Cairn Ryan will work in practice? Turning now to some of the other commitments set out in the command paper, on the new body intended to promote trade within the UK, Intertrade UK, which was announced, can he confirm when he expects this to become operational and how will it be overseen? I welcome the government's determination, this has been brought up by a number of members, to ensure that the continued supply of veterinary medicines into Northern Ireland beyond the end of 2025, when the current grace period expires, will be maintained, and we all hope that an agreement can be reached with our European partners as soon as possible. And indeed, I share the view that's been expressed by others in the debate, that we had the same problem with human medicines, and in the end, the EU recognised that something had to be done about that, and I hope very much that the EU will show the same spirit in approaching this question. The command paper, however, says, and I quote, "We will, if necessary, deploy all available flexibilities," end of quote, to safeguard and sustain the supply of veterinary medicines. Could he tell the House what these flexibilities are and how they would be applied if we get to that point? Madam Deputy Speaker, in approving these regulations today, which I hope we will do unanimously as we just did with the constitutional set, we'll be taking another step closer in this really important week to the restoration of power sharing. Now, the people of Northern Ireland, who have been without a government for so long, may not, in all fairness, be studying the regulations in the way that we are doing today, but they very clearly understand why they are essential to getting their government back. And once we've done our bit today, it will be over to the politicians of Northern Ireland, and I'm sure that every single member of the House wishes them the very best in the task that lies ahead of them.
Thank you, Madam Deputy Speaker. These important statutory instruments are the latest in the process of implementing the result of the 2016 referendum to leave the European Union. It may not have attracted the same volume or attention or emotion as those endless meaningful votes in 2018 and 2019, but it is no less important. It's been a long and difficult process which has divided the nation, but the end goal of restoring our status as an independent, self-governing democracy has been a prize worth fighting for. For centuries, members of this Parliament strived to ensure that we would be governed only by the laws made by our own elected representatives, and that's what Brexit seeks to deliver. But we all know that the job isn't yet finished when it comes to Northern Ireland, so I want to pay tribute to the work of the Secretary of State and the Minister and the DUP for their determination to tackle the problems with the Windsor Framework and secure Northern Ireland's place in the UK internal market. I very much welcome the advances being made towards restoration of power sharing and devolved government. I accept that these statutory instruments are an important part of enabling that to happen because of the significant changes that they contain. I, of course, completely understand the DUP's concerns with the Northern Ireland Protocol and the Windsor Framework. We must do all we can to minimise trade frictions between Britain and Northern Ireland. The agreement on the Windsor Framework started that process. For example, it made movement of medicines, food and items for retail sale much less problematic. I believe that further improvements will be delivered by the deal we're looking at today, by further reducing checks and inspections. My concern is that there's a central problem that remains, that Northern Ireland is subject to single market rules without having a vote on them. The instruments we're considering don't change that, though I do welcome the important further clarity and safeguards which are offered on the Stormont break. But the dialogue with the EU has to continue so that ultimately we can move to a situation where only items destined for export to the south are subject to EU rules and regulations in Northern Ireland. With pragmatism and advancing border technology, this should be possible, and it's important that we continue to strive to bring that about so that we can restore democratic control over making our laws in every part of our United Kingdom, and Brexit is fully delivered for Northern Ireland as it is for Great Britain. We also need assurances from ministers that nothing in Regulation 3 of the Constitutional SI will prevent regulatory divergence between Britain and the EU. Of course, any responsible minister must consider the impact of his or her decisions on the unity of the UK and its single market, but new screening obligations must not be allowed to create a chilling effect which would stop us charting our own course on how we regulate our economy. Taking back control of making our own laws was a key reason why people voted to leave the EU. We've yet to fully deliver that for Northern Ireland, and as I've said, we must go further on that in the future, and I'm happy to give way.
Very grateful to the Right Honourable Lady, and I'm grateful for the conversations that we have had around this specific point, and she is right to highlight her concerns and seek assurances from the government in that regard. But she does accept that as part of this, it is right to get assessments. It is right that government should always continually be going through the process of assessing what the decisions they make and the impact they have on every part of this United Kingdom, and that there's nothing wrong with transparency, and nor is there anything wrong with knowing what could be a consequence, and all of us determinedly trying to ensure that if it's negative, it doesn't arise.
I thank him for that point, that intervention, and actually the dialogue that he and I have had over recent days has done a lot to reassure me that what is in this package is about transparency. It's not about a block on divergence. And that is something I hope the Minister will confirm in his closing remarks. Because divergence is important, the regulatory reform made possible by exit is, I think, crucial for our future economic success. By making us more competitive, modernising regulation is a key means to boost growth, raise living standards and reduce taxes. In conclusion, Madam Deputy Speaker, it took courage and determination from Northern Ireland's elected leaders to secure peace after 3 horrific decades of terrorist violence. Asking very different parties to sit in a permanent mandatory coalition was never going to be easy, not least because some of the divisions between them date back decades or even centuries. That devolved government has worked for so much of the past quarter of a century is a testament to Northern Ireland's leaders and their determination to make the 98 settlement work, to make Northern Ireland work. And I want to pay a particular tribute to the DUP on this, for so often it is they who have found ways to fix problems and keep devolved government going, whilst always safeguarding unionist principles. And we in this House must recognise that significant problems caused by the Northern Ireland Protocol and the Windsor Framework, that of course includes what the courts have described as a subjugation of Article 6 of the Act of Union of 1801. But as we've heard in the debate today, we're making real progress on tackling these issues, setting out in these statutory instruments stronger legal protections for access to the GB market, and the historical perspective set out in Annex A, I think of the command paper, is something that everyone should read. We are making progress on remedying these problems. Madam Deputy Speaker, it was a privilege for me as Secretary of State for just under 4 years to play a part in Northern Ireland's inspiring story, and I truly hope that a way can be now found for its devolved institutions to resume their work of taking Northern Ireland forward to further success and an even brighter future.
So I'm just going to get an indication, because there were some people who had indicated that they wanted to speak but are now not standing. So, fine, that's very helpful. Thank you. SNP spokesperson Richard Thomas.
Deputy Speaker, we start out in these benches from the principle that the fewer impediments that there are to trade in between all parts of the UK and between the UK and the EU, the better. And that's something that clearly took a step backwards with Brexit. And so we welcome very much the fact that in terms of Northern Ireland at least, that that situation has been largely addressed with the regulations that are before us today. So we will be supporting them. Now, with that dual market access, Northern Ireland clearly enjoys now a highly advantageous situation relative to other parts of the UK. And while, as I say, we very much support this SI, my hope is that in time the people of England, Wales and Scotland will wish to rediscover that advantageous situation for themselves and ultimately render the content of this SI obsolete. Finally, Madam Deputy Speaker, it would be remiss not to miss the opportunity to tweak the Minister's tail slightly when he says that he's an enthusiast for democratic self-determination. So am I. And I look forward to a similar stout defence from the Minister of that right to democratic self-determination in other parts of the Union in the future.
Robin Miller.
Thank you, Madam Deputy Speaker. It's a privilege to speak in this debate and to follow the many honourable and right honourable members who have spoken with great wisdom and knowledge and personal experience on these. Madam Deputy Speaker, it's informative, I think, to apply the 4 tests for impact on Article 6 of the Acts of Union that were developed by Justice Colton, specifically Northern Ireland's compliance with certain EU standards, the bureaucracy and associated costs of complying with customs documentation and checks, the payment of tariffs for goods at risk, and the unfettered access enjoyed by Northern Ireland businesses to the EU single market. I do question the representation of the Supreme Court judgment as set out in paragraph 14 of the Annex A in the command paper. But those were matters for the last debate, and there was not time to make my point. Madam Deputy Speaker, regarding EU standards, the Windsor Framework removed many EU standards for GB-produced consumer goods destined for Northern Ireland. This does not change under this SI before us. Regarding the second test of bureaucracy and compliance costs associated with customs, this should concern us, as the protocol saw the diversion of £1.2 billion worth of goods in supply chains from GB to the Republic. Indeed, logistics businesses testified to the Lords Committee on the Windsor Framework as to complexity of managing mixed loads, with 2 large haulage firms stating that groupage had been, quote, forgotten in the framework. There's also been expert analysis suggesting that 75% of output in non-exempted manufacturing sectors, including electronics, engineering and chemicals, come from firms with turnover above 2 million, which will see therefore their GB supply chains stuck in the red lane or diverted abroad. The command paper published yesterday contains a pledge, a UK internal market guarantee, that no more than 20% of goods will flow through the red lane. In practice, this creates a monitoring panel to report on any failures, which the government, to hit the target and make recommendations which the government must respond to. This is admirable, but does not represent a material change to existing customs requirements under the protocol. It's also worth noting, worryingly, that this could be achieved by simply diverting supply chains away from GB and towards the EU, as affected GB businesses cut Northern Ireland out of their distribution chains. The SI before us creates important easements for the Northern Ireland to GB trade, including a guarantee that future divergence will not impact the ability of Northern Ireland traders to freely access GB markets. This is welcome, but the bulk of distribution has always pertained to GB to NI trade, not the reverse. And as also noted in the command paper, technology may ease compliance costs in the medium to long term. They will, however, still exist. Shipping from London to Belfast will continue to require significantly more bureaucracy than shipping to York or Edinburgh. Madam Deputy Speaker, the third test of tariffs is not covered and does not apply. But finally, in turning to Northern Ireland's preferential access to the EU single market, I must emphasise that the clear trade-off we have chosen to give Northern Ireland unregulated access to EU supply chains comes at the cost of complicating access to GB ones, despite the fact that Northern Ireland imports from GB are 2.5 times those from the EU and 6 times more than those from Ireland. Whatever easements we offer, this has created a customs, judicial and legislative border across the kingdom, and it is hurting our businesses. That Northern Ireland continues to have preferential access to the EU single market is unarguable, but this should not be misunderstood. And again, I find this final test informative. In conclusion, Madam Deputy Speaker, nothing I say here today is intended to diminish the achievement of the deal when it comes to material gain for Northern Ireland. I welcome the elements within it which offer undoubtedly increased safeguards for the Union. The new deal is welcome, therefore, but it does not change the fact of EU law's application to Northern Ireland, the fact of additional bureaucracy for GB businesses attempting to access Northern Ireland, the existence of tariffs, nor Northern Ireland's de facto placement within the EU single market. Once again, the qualities and effectiveness of this deal will emerge over the months and years ahead, I'm sure. And through the scrutiny that must come from this place in those months and years ahead, I will continue to offer my support. Oh.
Speaker, thank you. I'm very happy to let my colleague in if she wishes me to give way now in response to that.
It was just, thank you, Madam Deputy Speaker. It was just in reference to something that the former honourable member mentioned, and I just think it needs reiterated in this House today that if the people of England or Wales or Scotland woke up tomorrow morning and found that 300 areas of law they only had the right to stand for election to try and stop those laws imposed on them by a foreign parliament, it would be outrageous, and it would be seen as outrageous by the people in this House. So I think that point should not be lost on this gathering. Thank you.
Thank you, Madam Deputy Speaker, and I'm glad I allowed my honourable friend to make that intervention, albeit the contribution from the honourable member for Aberconway had concluded, because I think it is an important point to make. And within the context of this UK Parliament, Madam Deputy Speaker, I am proud to stand up today in support of the SI that is before us, but also recognise where we have been over the last number of years, trying to deal with and resolve the imposition that was imposed upon us and the people of Northern Ireland by colleagues in this chamber, by a government arising from the arrangements that they reached in the Withdrawal Agreement and the Northern Ireland Protocol. And when we did so, we took a series of measures designed to encourage those who didn't really concern themselves overly with the position that they had left Northern Ireland to make change to redress the harm. And today, in many ways, is a culmination of part of that process. But it didn't end or stop today, Madam Deputy Speaker. For the last number of years, my colleagues and I have stood firm in this regard. We have taken a principled position about the imposition of the Northern Ireland Protocol, the harm it has caused our country and our place within our country, and work determinedly for solutions. I will, surely.
Just on that point about the damage that has been done, and I'm looking at the diversion of trade that has taken place between Northern Ireland and the Republic of Ireland, and that many suppliers have found that it was easier to get product from the Republic of Ireland because their UK supplier was fed up with the bureaucracy that they were encountering. There needs to be a job of work done with the UK suppliers to ensure that they can pull back and bring back that trade.
He is absolutely right, Madam Deputy Speaker, and I think Intertrade UK, a body that you'll read about in this command paper, will have an important job of work to do in that regard. I remember back in 2022, whenever we were under significant pressure in October of that year to move, whenever we were under significant pressure to accept our lot, my parliamentary predecessor, former First Minister for Northern Ireland and my mentor, Peter Robinson, issued a very powerful post at the time, reminding colleagues, reminding those of us who were under the pressure that we hadn't come this far only to come this far. He was encouraging us to stand. And we stood our ground not only then, but right the way through all the hype and all the pressure associated with the publication of the Windsor Framework. Because the three fundamentals that are expanded upon in our 7 tests were this: we wanted to repair the constitutional harm imposed upon our country. We wanted to remove the democratic deficit that was at the heart of the arrangements for parliamentarians in our Northern Ireland Assembly. And we needed to reduce the friction on trade and remove it in respect of those goods from GB to NI that are staying within the UK internal market. That's been our quest. And when you think about those three propositions that I mentioned, repair the constitutional harm, well, Madam Deputy Speaker, I am delighted that as a consequence of our party's resolution, our party's determination and our stand over the last number of years, my right honourable leader, the member for Lagan Valley, was able to speak to, and this Parliament agreed, the constitutional SI that just passed in this House. And it's an important milestone. And when I think of democratic deficit, well, let's not forget that what has been achieved on repairing and removing the democratic deficit and given Stormont a say in the rules that apply to Northern Ireland didn't just come by way of change in this place. The agreement of that resolution required a structural amendment to the Northern Ireland Protocol. And Article 13, 3 and 4 of that protocol was amended. The Windsor Framework did that, and within the constitutional SI just passed, we have strengthened further still the legislative provisions around the operation of that process. And I say that to indicate that what we were told couldn't happen, changes to these texts, tablets of stone, happened. Yeah. And on the reduction of trade, I'm delighted to be able to speak in response to this statutory instrument before us, UK internal market and unfettered access. It is an important document, not in and of itself, but as part of a much wider package that has been secured and published yesterday as part of the command paper. It has import in and of itself, and today these proceedings have an importance attached to the prospect of a return to devolution. Our party is a devolutionist party. We believe in locally elected representatives in Northern Ireland having the ability to shape their future within our country, within the United Kingdom. And the cost and consequence of not recognising the opportunity before us, seeing the gains that have been reached, would be too damaging. Too damaging for unionism and too damaging for the future of our province in this country. But not all that's contained within this SI, or even the SI just passed, is the sum total of the culmination of what we have agreed. I listened to the Honourable Member of Aberconway, and he said, and he believes it so because it has been said so many times, but sure, there was no issue about goods moving from Northern Ireland to Great Britain. Not so, Madam Deputy Speaker. From 2017, successive governments on the benches opposite have always dismissed the fact that traders trade in both directions. And they've always answered through one prism, but never recognised that a marketplace is somewhere where you should equally be freely to buy and sell. And so in saying that it hasn't been a concern is to belie the fact that as unionists within this country, we had a situation where UK trade deals struck, and the freedom of doing so didn't automatically apply to us in Northern Ireland. And the consumers in Northern Ireland could not benefit from those trade deals. And yet, whilst not in this SI, I think it is worth mentioning that on Tuesday evening, as a consequence of our discussions and negotiations with the government, and published in this command paper, we saw the publication of 60 pages of legislative text that see rest of the world products freely available in the rest of the United Kingdom, now available in Northern Ireland, products taken from the red lane into the UK internal market system. 13,000 tonnes of product availability that wasn't available until we secured the concession which recognised our rightful place within this United Kingdom and our access to UK free trade deals. That's an important step. 14 million different items, 13,000 tonnes of products out of the red lane into the UK internal market system. Free trade deals benefiting the people of Northern Ireland in a way that they could not and in a way that they had not, and in a way that was never really considered but has been secured as progress as part of this agreement. You will recognise also, Madam Deputy Speaker, that not contained within this SI but contained within the deal itself, primary legislation will be introduced to remove what I can only describe as the legislative litter that is retained from 2017 in the joint report about this fictional all-island economy. It does not exist. The reason why goods are labelled when moving from GB to NI, not for the sale in the EU, is because we have a separate and distinct arrangement. We are not the same as the rest of the island of Ireland. We are part of the United Kingdom, and this deal reinforces that.
Member give way.
Certainly.
I'm grateful to the honourable member for giving way. I appreciate his concerns around the phrase the all-island economy, but does not recognise that there are a number of companies based in Northern Ireland who do operate essentially on an all-island basis. And his own party leader, for example, has highlighted the very obvious example of Coca-Cola, which is based in Lisburn, but services the entire island.
I think, Madam Deputy Speaker, the honourable member for North Down, and it's always good to hear his contribution, knowingly confuses the point that I was making, because he knows that Coca-Cola, situated in Northern Ireland and sending its product right throughout the island of Ireland, is a point that recognises access to the single market, which I take no issue with, and I see as a practical benefit. But he also ignores the fact that Coca-Cola Northern Ireland is able to do that, managing different tax regimes, managing different currencies, and managing many different aspects, each and of themselves, clearly demonstrating there is no all-island economy. I'm not concerned about there being one. I'm concerned that there's one reference left in a piece of legislation which is totally irrelevant, has no force and effect, requiring ministers to have due regard to something that does not exist. Does not exist, Madam Deputy Speaker. And yet it's part of this agreement, and I am grateful for it. And the changes to the lane system, let's put it that way, where under the protocol bill there was an acceptance of red and green, and under this arrangement there's no need for a lane that deals with goods that are coming from GB to NI and staying within this United Kingdom internal market. And under the Windsor framework, the checks that were required, yes, in global terms, tapering down to 5% by 2025, but in real terms, 100% on some fruit and veg, 30% on meat, fish and poultry, 15% on dairy. Gone. Save for the ordinary checks that you would have in relation to smuggling and criminality. Changes that can only be achieved by opening the EU text, Madam Deputy Speaker. Changes that can only be achieved by securing change in a way that we were told could not happen. Was mythical or wishful thinking. And to the SI itself, Madam Deputy Speaker, and you've been very gracious in letting me speak around the SI up until this point. Take the changes to the UK Internal Market Act. There were many things that were proposed by government in 2020 that were to be of benefit to us that the government dropped. They dropped them. They had our support in protecting our place within the UK internal market, and they dropped them, and this deal brings them back again. But it goes further than that. And I know it has been commented upon by others so far, but let me quote 45A 2A. Accordingly, this Act prohibits the application of export procedures to goods removed from Northern Ireland to Great Britain. Whether you think it has practical import or not, let me tell you as a unionist, it has principled import. There should be no exit procedures, but there have been under the Northern Ireland Protocol that caused us so much harm, and they're gone, Madam Deputy Speaker, and that is important for all of us. The third subsection there, in particular, that permanent unfettered access is achieved in relation to qualifying Northern Ireland goods through, amongst other things, mutual recognition, Madam Deputy Speaker. Mutual recognition. Heard of it before? Discussed many times in this House. an aspiration of all of us, something we were told was mythical, something we were told was a unicorn project, something we were told could never be achieved because the EU would never agree. And yet here we have, in this SI, mutual recognition. Something that could do away with the checks and the impediments and the impositions that were put upon us by this Parliament. Something that could have resolved the barriers to trade within our own country, and something that caused a consequence to the principled and political integrity of our country. Gone, because we've now achieved mutual recognition. And why is it important? It's important in the context of the debate that we were having across the House. I am proud that we have put in things that probably seem a little boring, probably seem a little methodical, probably seem a little bureaucratic about internal market impact assessments. But even if we go through the process of getting civil servants and policy makers to understand that any choice they make could have an impact on the UK internal market and Northern Ireland's place within it, understand what those are and seek to address them, even if the conclusion is that parliamentary sovereignty reigns and that principal policymakers in this place decide that they will diverge in policy terms from where we are in Northern Ireland, we have a goods guarantee. Nobody in these benches is going to upset parliamentary sovereignty, but we will protect our place within this United Kingdom. And so when I point to the goods guarantee, the mutual recognition that says, irrespective of the standards that apply in either part of this country, that our goods from Northern Ireland will always be welcome in the rest of the United Kingdom, that is a gain, Madam Deputy Speaker, and that is a gain even when others didn't see it as a problem, because it future-proofs our place within this United Kingdom. It was something that was absent from the Windsor Framework. It was something that has been a long quest of all of those who have walked hard yards on resolving some of the issues that have arisen from our choice to leave the European Union. But our determination has never wavered, Madam Deputy Speaker, on those issues, and a resolution has been achieved. In the amendment titled 46A, and it deals with indirect access, here we have our government now saying very clearly that there can be no checks administratively, controls, processes, not only in direct movements between one part of our country and another, but indirect movements. Direct movements, but for the fact that the goods have merely passed through the Republic of Ireland. Crystallising yet again, we're not in an all-island economy. We are different from our near neighbours. We are different from our near neighbours. And legislatively, Northern Ireland hauliers, Northern Ireland businesses who are sending goods from Northern Ireland to Great Britain will be able to do so in an unfettered way, even if they travel through a foreign country, and in a way that does not apply to them. Those achievements are worth focusing on, Madam Deputy Speaker. Worth focusing on because we have been trying to resolve the unresolvable. We have been trying to get focus in places where attention had changed elsewhere. I can stand here and say it has taken much longer than we would have liked. I'm sure there are many on other benches would say that they would have preferred it to end a lot sooner as well, only if we had agreed less. But we were not prepared to do that. Windsor Framework marked the progress, but we said there were unresolved issues, not only in the potential for future divergence in GB that would put us in a difficult position, gains that were offered in the Northern Ireland Protocol Bill, or indeed the UK Internal Market Act that were ultimately dropped, which we have now brought back and secured, and this Parliament is agreeing. But, Madam Deputy Speaker, resolving the unresolvable in a way that will have practical application for Northern Ireland and our place within this United Kingdom now and for a long time to come.
I have 3 more speakers. I want to bring the Minister in at 3:18, so perhaps people could bear that in mind. Julian Smith.
Deputy Speaker, and I again pay tribute to my right honourable friend, the Prime Minister, all of the Northern Ireland parties and, most importantly, the DUP on this negotiation. And again, thank the opposition for their support, and note that this instrument, like the last instrument, is liable not to go to a vote and, again, have total unanimity across this House. And I think it's really important for us to continue to make that point. I know the DUP were very concerned that measures were dropped in 2020 from the UK Internal Market Bill, and I'm delighted to see those protections returned. And I think this instrument, again, like the previous one, emphasises how they have negotiated all the detailed elements that my right honourable friend has just outlined, matched by a blank sheet from those who are currently making arguments against the DUP's acceptance of this deal.
Deputy Speaker, I thank the right honourable member for giving way, and I thank him for his work in terms of trying to move things forward. Does he agree with me, the very point that he has just made, that it is the tenacity of my colleagues and I in not giving up when in 2020 those clauses were dropped, but we persevered and we kept pressing when others gave up? This party kept at it. And now today we see the fruits of our labours with the insertion into the UK Internal Market Act key clauses that protect our unfettered access to the United Kingdom and its internal market.
I wholeheartedly agree with the leader of the DUP because this negotiation, as I have observed, has been hours and hours from the negotiating team, from my right honourable friend, the Secretary of State, from the Prime Minister's team, and it has been dogged, and it has been ongoing, and it has been hours of work. And I observe some of the debate in Northern Ireland and some of the criticisms, and I look on at the list and lists of improvements that have been won through this negotiation, and again I pay tribute to those improvements. But this legislation and this instrument, Madam Deputy Speaker, speaks to a broader point in Northern Ireland, and that of the economy and the opportunity economic improvement. And before talking briefly about that, I'd like to pay tribute to those business groups in Northern Ireland who have shown great patience since the Brexit vote on how to resolve many of the issues, many of the practical issues that we're faced with. The Chamber of Commerce, the CBI, the IOD, the FSB, the Brexit Working Group, many people have been working very hard to seek resolution, and I know that each and every one of those organisations will be pleased with what they have seen this week. There are huge opportunities in Northern Ireland for the defence sector, the cyber sector, agriculture, pharma, and more. And I think that whether it's meat exporters who will be welcoming the tariff deal, or whether it will be the many businesses that are working with the US Special Envoy this week in Northern Ireland, or whether it's the various economic and inward investment seminars and activities that my right honourable friend, the Secretary of State, has been organising, all of these businesses will benefit and will create jobs and opportunities for families and for young people and for citizens in the future. I would also like to slightly move away from the statutory instrument itself and go back to the command paper and reference the paragraph on corporation tax. What has been negotiated by the government and the DUP on that front is to begin a working group between the Treasury here in London and the Finance Department in the Northern Ireland Executive to look at the competitiveness of Northern Ireland corporation tax, and that gives Northern Ireland an additional opportunity to maximise its already unique position in the United Kingdom.
For giving way. Can I also draw his attention to a further element of the command paper, which proposes an investment zone, a special investment zone for Northern Ireland, which will deliver an extra £150 million of funding to drive the growth in our economy? And does he join me in welcoming the interest of the Secretary of State for Scotland in working with us to ensure that the ports of Cairnryan and Stranraer are included so that the links with Larne and Belfast are strengthened, and that union connectivity that binds our country together is valued, invested in and expanded for the future.
I absolutely agree with those comments, and we're seeing it in this document on Intertrade UK, where I'm hoping there'll be excellent subject matter experts there to build the trade opportunities further, and through the East West Council and various other groups. I think this document is much more than a constitutional or a legislative document. It is the basis for building on the already extremely exciting opportunity that Northern Ireland has to conquer in multiple sectors of the economy. I think now we'll be moving on, I presume, to looking at talent, to looking at skills, to looking at how people from poorer nationalist area or poorer unionist area can maximise these economic opportunities. But this document is the basis for moving forward for Northern Ireland under a new devolved executive, and Northern Ireland knocking the lights out in various sectors of the economy in years to come.
Two more speakers, and I would suggest that 9 minutes each should do it. Jim Shannon.
Thank you very much, Madam Deputy Speaker, and it really is a pleasure to speak in this, and I adhere, as I always do, Madam Deputy Speaker, to your time scale as well, because my right honourable friend from East Antrim has a lot to say as well. Can I just say, first of all, that the combination of years of negotiation have to be recognised. There has been movement, and even the harshest critics must be fair and admit to the huge steps that have been taken. At this point, I believe it is right and proper, Madam Deputy Speaker, and I thank those in the Democratic Unionist Party negotiate them, my leader and my deputy leader, right and left of me here in this chamber, and all the other ones who have done that, the Secretary of State and others with influence. The honourable gentleman who spoke before has been a great advocate for unionism in Northern Ireland. We thank him for that as well. So I'm grateful for all those who have done the bulk of the work by tirelessly advocating for change. Now, they have secured a deal. I'm thankful for that. However, I must be clear, this is not the fulfilment of a wish list. Does it go as far as I wish to do? No, I have to say that I wish to see more, but how do I change that? I change that from in this House. I change that within this Westminster House of Commons. That's how we do it. As a Democrat, that's how I feel we must. Right. So I think that's the point I wish to make. I'm an active constituency MP. All of us are, by the way. I'm not saying nobody else is. When I say I've travelled the length and breadth of my constituency with this, that is exactly what I mean. I met with Orange Brethren, Orange Sisters at the installations in January of this year, and same last year. I met the teachers, I met the NHS workers, I met individuals, community groups. I took time on the doors to explain to my people why we had to take the necessary step of bringing down Stormont, to try to provide the justification for staying out of Stormont during times when money was being withheld and every threat other than physical was being launched at us, to attempt to tell people that it wasn't a matter of us being thrown, to use an Ulster Scotsism. It was rather a matter of us taking seriously the economic and constitutional position of Northern Ireland within the Union. That's what I've done. Sorry, what my colleagues have done for the last 2 years. I've stood firm on this in the 7 tests which the DUP had outlined. Now we stand on this day and see the legislation that I call for, others call for, constitutional legislation to secure our place within the internal market. And I still retain some level of concern and press government for more assurances. You expect me to do. Sorry, the minister will expect me to do that. It was highlighted yesterday that the European laws may be overruled by government. The wording of that suggests that they may also be accepted, allowing Northern Ireland to diverge, and many of the people that I represent, indeed all of the people that I represent, seek an assurance from this government, from our government, that this deal in legislation before this House will do exactly what it says in the tin and secure our place in the internal market. In fact, restore and then secure our place. The lack of trust, Madam Deputy Speaker, I've said it gently, I said it very gently to my colleagues across the way and indeed across this chamber. The lack of trust boils down to the treatment of unionists by ruling governments in this House for decades. The Secretary of State very kindly in my intervention took that on board, and I'm looking forward to that trust being built upon in a way that we can secure the trust of the people that I represent, and I'm very privileged to represent in this House. The Irish Government has no issues about supporting calls for reunification, and yet our government, our minister, has been afraid to appear unbiased. Government need to be unbiased. The opinion of this House on our sovereignty should be clear. And I can see that my party leader sought not simply to secure legislation and change for this to take place now, but to future-proof it. In other words, we're not just dealing with it today, we're dealing for the future, for my children and for my grandchildren, and for some of those that I probably won't be here for. The difficulty is that many people that I represent have stated their lack of trust in the government, which told us that they gave us their best that they could, and then have not delivered, which I'm very happy to, yes.
I thank the honourable member for giving way, and he makes a very powerful point around trust, and I believe the way that the people of Northern Ireland over the past number of years have been treated by this government is terrible. You only have to look at the abortion laws that were forced on the people of Northern Ireland. You have to look at the RSE educational change that has been brought into Northern Ireland. So trust is at an all-time low, and I can tell you now there are people within my constituency who look at this through the prism of not rose-tinted glasses. They look through the prism of needing to go much further and do more. Thank you.
And colleague for that intervention. And yes, I think the Honourable Lady very clearly illustrates the distrust that there is. I think that to be fair, the Secretary of State and the Minister of State have recognised that, and they know the job they have to do. I am sure it's clear why some of my electorate don't question the dealings of the DUP, but rather the questions of government, wondering if this deal is deliverable and will stand the test of time. That's why the methodology that we have before us, Madam Deputy Speaker, and how government must take a step, and only when they take that step can we then on this side look at that to take a surrender, wondering if this deal is deliverable and will stand the test of time. That is what the issue boils down to, and why I express concerns, a huge lack of trust, and that has spilled over to many unable to accept the spirit of the deal. And in all honesty, I fully, and I say this very respectfully, I fully understand the distrust. Just to give you one quick example, in the short time I have, on Tuesday morning when I had the opportunity to look over the deal, some of my, I know the gentleman has been in touch, not just with myself, but with my other honourable colleagues on the side of the chamber as well. And he says, Jim, I'm going to test this out to see if the paperwork is less. This is Tuesday morning. He came back to me Tuesday night. He sent me a text today. I think others may have it, to say that the 251 products that had each got 300 papers of individual paperwork to do, that paperwork was away. Yeah. He also told me that the pet foods that he couldn't get in 3 weeks' time, he will be able to get. Yeah. Now, that has to be progress. Now, why does that happen? It happened because of some of the things that have been done here. I took the opportunity to speak to the business, speak to the farmers. The farmers have told me, also Farmers Union brought to me as well, they've told me that as far as they're concerned, they see progress in the machinery and progress in the tractors and progress in vehicles as well. The vets' medications, the Minister of State, in an intervention I did earlier on, I mentioned to him about the importance of having that veterinary committee. And I would like to see if I can make this plug for my honourable friend, the member for Northampton, to be a member of that. But his influence in that will be critical and important. He's done the spade work. He seems to me to be the right man to be in there to fight for us. My electorate want their representatives back to Stormont, but not at any price. Rather than the spirit of Chamberlain's peace at any price, which emboldened our enemy. They hold to the mantra of Churchill, we will fight them on the beaches, and how true that is. We have sought to secure the internal market, but the reading of the SI makes clear that a lot of interpretation is in the hands of the sitting government. My constituents are desperate to get the billions that have been willfully withheld. I did this with great respect to the Secretary of State last week, and those awaiting treatment in the NHS list deserve funding to reduce their time and pain. The bus drivers standing a few yards down from my constituency's office in the freezing cold deserve that pay rise, and yes, they do. The children with special needs deserve the security of knowing their day centre will remain open and not closed to insufficient funding. They deserve these. All of these deserve these, whether this deal was struck or not. But we also deserve the truth of who we are in the light of the legislation. Are we casual members? I'm going to finish, I'm rushing very quickly towards that time. With the EU on a continual bias to have a say in laws and recognition of status, or have we fully employed UK membership with the benefits and security of every other part of the UK? The deal has been hard fought for, seeks to address that. But the real power to assure lies in this House, lies with the ministers, lies with government. At home, people are urging us to keep our word. I agree we must, but we can only do so if government in this place will also keep their word. Northern Ireland deserves our place. My party leadership have fought hard. The question is simple, and so is the answer I seek, Madam Deputy Speaker. Are we British in law, in economics, in party, or are we not? Speak the word today and ensure that my government, the ministers here, keep it tomorrow. Thank you.
Well done, Jim.
Well, Sammy Wilson, and then I'll bring the Minister in at 3:18. Sammy Wilson.
Deputy Speaker, and I'm not going to go over the wide range of what's in the command paper or the SI. I want to focus on some particular points in the SI. It's well known that I do not support this deal, this agreement. I've given reasons why not, and I think that it's important that we do have the opportunity to examine the detail of it. And I've got to say, I don't think that the way in which this has been hurried through today allows the examination. And it's one of the reasons why I'm going to focus just on one particular aspect. The member for East Belfast, when he was speaking, talked about the need to get rid of some of the debris, the legislative debris or litter that was still around. And the first thing I want to make, and maybe the Minister can answer this in his summing up, there's a lot of legislative litter which is still around as a result of the arrangements which were in place for the red lane and the green lane. There were SIs which I spoke on in committee on a number of occasions. There are EU regulations, Regulation 1231, which gives the EU the right to make a final decision to suspend goods going through the green lane, or indeed, I suspect, the internal market lane, and make the red lane the default position. And I wonder when we're going to see all the infrastructure that was around the previous arrangements in the protocol and the Windsor framework removed, because that would indicate that, first of all, the UK government was totally in command of goods flowing into Northern Ireland, and not, as the legislation, EU legislation, and indeed the withdrawal agreement states at present, the EU having the final say. The second point I want to make is around the movement of goods between Northern Ireland and GB. And the member for East Belfast has indicated that it was an issue of concern. It is an issue of concern. And indeed, it is likely to be an issue of concern in the future. And especially since in the previous SI that we looked at, the SI makes it quite clear that there could be legislation introduced in this House which would impact on trade between Northern Ireland and GB as the government decides to change, for example, some of the retained EU law. And the only assurance which is given is that, first of all, a minister would have to make an assessment of the impact, report it to the House, but at the end of the day, and it's quite clear in Article 13C, at the end of the day, he could make a decision to proceed nevertheless, even though that trade was likely to have an impact on trade. But there's another reason, because EU law could be another reason for divergence, and also we could find that there are decisions made or there are practices allowed in the EU which put the GB market at risk, and that's why we have now introduced, or we will be introducing, the border operating model. Now the danger is that Northern Ireland goods could get caught in that. Now, I can imagine immediately I'll hear people saying, and the Minister probably saying, but the legislation prevents that, and it does, on the face of it. We cannot have any border checks for what are called Northern Ireland qualifying goods going into GB. And indeed, local authorities will be informed that you can't restrict trade, no barriers can be put up to that trade, and Northern Ireland qualifying goods should have free access. And of course, all of the export declarations that were required in the past are to be dropped, though maybe the Minister can tell us what he is meant by 46A when it indicates that when it indicates that there are 46B, sorry, if goods fall into one of 5 categories, then they will require export declarations. But leaving that aside, let's look at the situation, and it's provided for in this legislation actually. Let's look at a situation where it is quite clear that the freedoms given for Northern Ireland qualifying goods to sail through into GB are being abused by exporters from the Republic who bring the goods through Northern Ireland, declare them as qualifying goods, and by the way, it appears from this legislation that there's no evidence which has to be given. This will be simply taken on trust, that if you say the goods are qualifying goods, and I see the Minister nodding his head, so maybe he can tell us what proof companies have to give and how onerous that proof will be, but goods move through Northern Ireland in the GB. If it becomes clear that that is being abused, what happens in that situation? Now, it appears that the SI, and again, if I'm misreading it, the Minister can explain this to me. SI in 46A indicates that the previous 45C indicates that guidance will be given to local authorities, public bodies, etc., as to what needs to be done to keep the free flow of goods going from Northern Ireland to GB. But in 46A, the Secretary of State may revise or revoke in whole or in part any guidance issued under this section. So in what circumstances would that guidance be given? And if that guidance were given, then what would the impact be on the free flow of goods from Northern Ireland to GB, which is over 60% of our market? Now, this is, I think it's details like this, because you see, when we have the kind of seal of an agreement with all the kind of wide-ranging and broad brush aspects of it, we then find that sometimes when we get down to the detail, as happened with the Windsor Framework, don't forget it, it fell apart within about 2 days of the assurances being given by the Prime Minister. It's important that we understand what all the various scenarios are that are being painted in a detailed SI like this. So I would ask the Minister, first of all, to give us an assurance what is happening to the Green Lane infrastructure, the SIs, the EU regulations. Are they being removed, or will they stay in place as part of the Windsor Framework and as part of the protocol and the withdrawal agreement? Secondly, when it comes to the goods which are going to require export declarations, the 5 categories, what are they, so that people know? And thirdly, when it comes to the goods flowing into GB, under what circumstances will the border operating model be applied to them? The last point I want to make is this. The last point I want to make is, well, I've only 1 minute left. On paragraph 100, we are told that for goods going through the Green Lane, there will still be some declarations which are required containing standard commercial information. Perhaps the Minister could tell us what standard commercial information will companies still be required to supply in order to comply with the data, which will still be, and even in the agreement, is still indicated will be required. Thank you.
Minister.
Thank you very much, Madam Deputy Speaker. And time is now going to be short. I'm going to do my very level best to answer as much as I can of what's been brought forward. It's been a very interesting debate. The right honourable gentleman for the opposition asked me about which checks will be eliminated. The changes will apply for both identity or visual checks and physical checks. We will take powers shortly to make direction to DERA to ensure that this is the case. The definition of qualifying Northern Ireland goods changing. Yes, we will require qualifying Northern Ireland goods to have a genuine connection to Northern Ireland and not to be merely passing through Northern Ireland. The SI requires qualifying Northern Ireland goods to be dispatched from NI-registered food business operators. And it concentrates competitive advantage on Northern Ireland firms. On future changes, we will continue to engage closely with Northern Ireland businesses and will always be responsive if arrangements need to be improved, a theme which I think I can safely say runs throughout everything the government will do. The honourable gentleman asked when we'll bring forward guidance on section 46. We will work rapidly to deliver on every aspect of the deal announced yesterday, and guidance on section 46 of the UK Internal Market Act will be prepared as quickly as possible. I certainly hear him on this point, and I know he will continue to press us. The guidance will help to avoid unnecessary gold plating. He asked me about Cairn Ryan. EU goods arriving at Cairn Ryan will be checked in line with the border target operating model, but I can confirm there will be no BCP at Cairn Ryan. We're working through the options and will work closely with the devolved governments, including a newly restored executive, that achieves our shared objectives. He asked about flexibilities on veterinary medicines. We are committed to exploring flexibilities that can be deployed consistent with international law to guarantee supply of veterinary medicines in Northern Ireland. We will establish a veterinary medicines working group to identify possibilities, possibilities in this area, but I'm not in a position to set out those flexibilities now. But what I would say to him is, having put so much effort, all of us, into resetting the relationship with the European Union, I very much hope and expect we will be able to succeed in a negotiation. My right honourable friend, the former Secretary of State, made a powerful case with which I agree, that Brexit must be fully delivered. And I just want to reassure her that nothing in this deal will prevent us diverging. And for the record, there are no commitments of any kind as part of this deal to align Great Britain with EU law, to prevent Great Britain from diverging from any retained EU law, or to increase alignment in Northern Ireland beyond the strictly limited scope Parliament has approved, which is itself subject to democratic consent and safeguards. For the avoidance of doubt, there is no legal mechanism to prevent divergence or force alignment across the whole of the UK. Ministers do retain full freedom to diverge from retained EU law. But of course, in this debate, there have been, both sides of this argument have expressed concern. So I just want to draw the House's attention to paragraph 150 of the command paper. Internal market assessments will be publicly available so that the change will enable Parliament and the Northern Ireland Assembly to more readily have the information they need for their scrutiny functions. These steps will fundamentally rewire structures within the government to ensure full consideration of the potential Northern Ireland impacts of any measures, ensuring that the internal market is integral to policy development. Of course, we will continue to work with all parties on outstanding issues. I am extremely short of time, but out of respect, I will give way.
Admit that the bottom line, as contained in 13C 2B, a statement to the effect that the Minister is unable to make such a statement, i.e. that it won't affect trade between Northern Ireland and GB, but Her Majesty's Government nevertheless wishes the House to proceed with the bill, is possible. So the bottom line is that yes, divergence can happen and trade can be disrupted.
I readily concede that yes, there can be changes to retained EU law and divergence can happen. But we have set out at some lengths the safeguards. And I would also say to him, as I think my right honourable friend for Skipton and Ripon, who made an excellent speech, said, I would encourage anyone, as indeed the right honourable gentleman opposite said, anyone to look at the section of the command paper in relation to the Act of Union. I myself learnt a great deal about it. I don't want to give way again because I'm going to need to finish in 1 minute. I will give way to him, I must.
Deputy Speaker, can I draw his attention to paragraph 146 in the command paper, which makes very clear that where primary legislation does carry implications for the internal market, the government will set out measures it proposes to take to protect Northern Ireland's place in the internal market.
I'm grateful to him, Madam Deputy Speaker, and yes, that is the position. And, you know, I think in closing this debate, Of course, there are sensitivities on all sides, as we've heard in the course of this debate. But, you know, real life in the age of intervention is complex, and we will press on as best we can. And with that, Madam Deputy Speaker, I believe this government has kept to the timetable as we agreed. I very much hope that we will be able to look forward now to a restored executive, one which we will be very, very pleased to support in serving the best interests of all the people of Northern Ireland.
The question is the motion on the draft Windsor Framework, UK Internal Market and Unfettered Access Regulations, as on the order paper. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. Order. Order.